Good
Queen,
morning.
Good morning.
I am the registrar for this hearing. Justices of the Constitutional Court, all counsel are online. I call the matter of Esorfranki Pipelines, PTY Limited, and Mopani District Municipality for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
Between now, Ms. Queen, between now and when you come back on again, please make sure you attend to the echo. You have an echo.
I will. Thank you, Justice Madlanga.
Thank you. Yes, Counsel.
I please you, Justice Madlanga and Justices of the Constitutional Court. I appear with my learned friend, Mr. Woodrow, on behalf of the appellant.
May it please you, Justices, I appear for the respondent with my junior, Mr. Mutsipe.
I see that I had muted myself. I said thank you, Mr. Luderis, and thank you, Mr. Mutipe. Yes,
Thank you,
yes, Mr. Luderis.
Thank you, Justice Madlanga. Justice Madlanga, as I indicated to you during the informal meeting with you, we do not intend repeating the submissions that we have made in our written submissions to the court. We will make certain brief submissions as regards the jurisdiction and leave to appeal. And then we propose dealing with submissions made by our learned friends in their heads of argument. I also indicated to you, Justice Madlanga, that we don't require immunity and that we are happy to deal with questions raised by the bench from the inception of our argument. If I may then deal with the issue of jurisdiction and the application for leave to appeal. We deal with that topic in paragraph 114 on page 44 of our written submissions to the court. It is perhaps useful right at the outset to remind the court of the finding that was made in the Supreme Court of Appeal by Justice Goosen at paragraph 66 of the judgment, where Justice Goosen found that the uncontested evidence unequivocally established deliberate and intentional conduct, and we insert on the part of the administrator to subvert the prescripts of section 217 of the Constitution. What lies at the heart of this matter, Justice Madlanga and members of the court, are the legal consequences of a failure on the part of the administrator to uphold the values of the Constitution and to respect, protect, and promote the rights enshrined in section 217.
Can you just reduce the sound?
Of the Constitution. Sorry, Justice Madlanga, there was just a bad echo for one moment. The case, Justice Madlanga, is similar in a number of respects to the judgment of this court in the matter of F versus the Minister of Safety and Security, which we reference in footnote 174 on page 48 of our written heads of argument, a matter similarly concerning the state's constitutional obligations to respect, protect, and promote the values enshrined in the Constitution, and in that particular instance, the values enshrined in sections 10 and 11 of the Constitution. Similar to this matter, the matter in F versus the Minister of Safety and Security also proceeded to this court from a decision of the Supreme Court of Appeal, where the justices of the Supreme Court of Appeal were, as in this matter, divided on the approach to be taken. In paragraph 38 of the judgment, the court, or this court, found that in the light of the substantial different approaches of the majority and minority decisions in the Supreme Court of Appeal, it is necessary for this court to address these issues. In addition, the applicant has reasonable prospects of success. We would submit that in this particular matter, first of all, clearly a constitutional matter is properly raised and placed before the court for adjudication that we have already identified. And secondly, we submit with respect that the matter before the court raises an arguable point of law of general public importance. We did offer in our heads of argument the judgment of Steenkamp in support of our argument that this is indeed a matter that raises constitutional issues, and we submit on that basis that leave should be granted to the applicant to appeal to this court and for its appeal to be heard and determined by this court. Justice Madlanga, if I may then move to deal with certain submissions made by our learned friends in their heads of argument.
Mr. Lodres, I'm not sure where you are going to start, where you deal with the submissions that have been made by the respondent. When you deal with factual causation, I'd like to put a question to you. So I don't know whether it is opportune to do that now or wait until you get to factual causation.
Justice Chiki, I'm happy to respond to your question right away.
What is your submission regarding the finding by Nichols J.A. that even if it were found that the joint venture should not have been awarded the tender, it was not proved that your client would have been a successful bidder? The way I understand Nichols J.A.'s finding, it seems to have been influenced by the fact that there was no obligation on the municipality to award the tender at all.
Thank you for the question, Justice Chiki. What we know is that the tender was to be adjudicated in terms of the PPPFA Act, and that a scoring system of 90-10 was to be applied in the adjudication of the tender. We deal with that issue in paragraph 95 on page 38 of our written submissions to the court. There is no dispute on the papers that, first of all, Esorfranki was the lowest competitive bid that was submitted in response to the tender, first of all. And second of all, that once a correct scoring had been applied, in other words, once the deliberate manipulation of the scoring by the municipality had been disregarded, that Esorfranki would have been the highest scorer insofar as the bids are concerned, and applying the PPPFA Act and the 90-10 scoring system that was applied to the adjudication of the tenders, that would, without any doubt, have left Esorfranki as the only successful bidder.
Sorry to interrupt you, but was there an obligation?
Yes. And
was there an obligation on the municipality to award it at all, even if they scored? The reason I'm asking this question is, from the papers, it seems that there was some form of a collusion. In fact, the High Court and the Supreme Court of Appeal found that there was some form of a collusive relationship between the municipality and joint venture. So suppose they then decided, that is now the municipality, because of the collusive nature, that their preferred bidder didn't qualify, then they decide that they were not going to award the tender rather than to award it to somebody else.
That we would submit that if that was in fact the approach to be taken by the joint venture, by the municipality, and if the municipality would have persisted on that basis, that would have supported a further ground of review to set aside a refusal on the part of the municipality to award the tender to the highest scoring and lowest priced bidder. And the provisions of the PPPFA Act was specifically ordered to be applied to the adjudication of the tender in terms of the order of Justice Preller that appears at page 255 in volume 1. And we specifically invite the court to numbered paragraph 5 on page 256 of the order, where Justice Preller ordered that the adjudication will take place in terms of the provisions of the Preferential Procurement Policy Framework Act using a 90-10 point system, where 90 points are allocated towards price and 10 points allocated towards equity promotion goals. That order and the argument advanced by the respondent, and which appears to have found favor with Justice Nichols in the Supreme Court of Appeal, is with respect inconsistent with the judgment of this court in the matter of Trencon Construction, PTY Limited versus Industrial Development Corporation of South Africa Limited. The case reference is 2016 JOL 33413, a judgment of this court where a similar argument was advanced by the IDC. And in paragraph 62, under the heading discretion not to award the tender to the highest points earner, this court found as follows. The IDC argued that it had a discretion not to award the tender to the highest points earner. During oral argument, the IDC conceded, however, that this discretion is constrained by Section 21F of the Preferential Procurement Policy Framework Act and Clause F3.11.3D of the Standard Conditions of Tender. These clauses require the IDC to award the tender to the highest points earner unless there were, quote, objective criteria, close quote, and justifiable reasons not to do so. And then continuing in paragraph 65, the court said, since Section 21F of the Procurement Act is peremptory, in the absence of objective criteria, the IDC would not have been justified in not granting the award to Trencon. It was the highest points earner, and following its consideration, EXCO did not cite any other basis barring the material error of law to have deviated from Section 21F. The judgment then continues, but the point that is made in this judgment is that unless objective criteria or justifiable reasons are established, the municipality would have been compelled to award the tender to the highest scorer and lowest priced qualifying bid.
Thank you, Mr. Rupert.
Mr. Luderitz, if I may just take up from what my sister has asked you on the point in the Trencon case. Aren't there in fact objective reasons in these circumstances why a retender might have been required? Because many of those who had tendered upon a proper consideration of their tenders were disqualified. And consequently, there wasn't a true competitive bidding situation. I think your case is that your client was really the only qualified bidder. And if that is true, then that would not suggest that a sufficient number of qualified bidders had put forward bids to create the competitive conditions under which the tender could have been awarded.
Justice Interalter, the lowest priced, highest scoring qualifying bidder was indeed the appellant before this court.
How many other qualified tenderers were there?
I will have to, if you will just bear with me for
Yes.
one moment. The list of bidders is identified in Annexure A at page 258.
Yes.
The other bidders that were disqualified, there is no suggestion that other bidders were erroneously disqualified.
No, indeed, but my point isn't whether they were erroneously disqualified. The question is, how many bidders were there left in the race after you had eliminated those who were considered when they shouldn't have been, and those who were excluded because they also should have been excluded?
That appears, Justice Unterhalter, from page 439, where the various bids are identified and where they are ranked, and where the scoring system is applied in order to discern which of these bids are in fact responsive bids and are compliant with the CIDB grading requirements. But if I may say, there is no suggestion that any bidder was unlawfully disqualified from participating in the bidding process.
Yes, no, I don't think, if I may interrupt, I don't think that's the issue. The question is, after the legalities had been resolved through your review process, would the municipality not have been in a position lawfully and under the guidance of TRENCON to say, well, this process has been distorted to a point where I'm not certain that there's sufficient competitive bids in play. I want to start again. And the tender, in fact, provides for that to take place.
Well, that was certainly not the approach that was adopted when the process was reviewed the first time by Justice Preller. What happened as a consequence of the review by Justice Preller is that a new tender invitation was extended. Various parties responded to the tender invitation. A number of those tenderers were disqualified on the basis of their failure to meet the minimum, amongst other things, the minimum CIDB grading. There is no indication that any one of those tenderers were unlawfully disqualified from participation. That left a specific number of participants that qualified for participation in the tender process. It included the joint venture, which we say and which the court found should have been excluded by the reason of the fact that its tender simply didn't qualify, and that was also the basis upon which other tenderers were legitimately excluded from the tender process. But of the remaining tender participants, the appellant was the lowest priced and highest scoring tenderer. And but for the unlawful award of the tender to the joint venture, we can conceive and know facts have been offered by the municipality that would support, consistent with the finding in TRENCON, objective criteria or justifiable reasons not to have awarded the tender to the municipality. It's a difficult argument with respect for the municipality to advance for the simple reason that it would have been the municipality that would have been duty bound to place evidence before the court to show that there were in fact objective criteria or justifiable reasons for it not to have awarded the tender to the applicant or the appellant in circumstances where it was the lowest scoring, highest scoring, lowest priced tenderer. But no such evidence was placed before the court a quo, and to that end, and absent any indication of an objective criteria or justifiable reasons militating against the award of the tender to the appellant, we submit that it must be accepted that the municipality would have been duty bound in terms of the provisions of the Preferential Procurement Act to award the tender to the appellant.
Yes, thank you.
Mr. Luderitz, just to follow up in a similar line, and I'd like to refer you to two references in the record, please. The first is at volume 5, page 438, and volume 7, page 679.
Justice Stone, may I just have one moment, please, just to locate the two.
So the first reference is in volume 5 and the second is in volume 7. Volume 5, page 438.
Thank you, Justice True.
The report says, it's in paragraph 6, line 4. It is considered that the project cannot be effectively completed for less than 2 billion, and that any tender of less than this amount will not be cost effective, and such tender is not an acceptable tender. It appears that a number of eligible tenderers who had submitted lower priced bids than the applicant were disqualified on the basis that if there were bids, their bids were less than 2 million, it would not be an acceptable tender. Now, before I put my question, I'd like you to look at Mr. Reeder's affidavit in volume 7, please, page 679, paragraph 59B. It's the first paragraph on that page. And it says, the first respondent appears to have favored bidders who bid at higher prices, but what the first respondent calls more realistic prices, this is an irrelevant consideration in that the 90-10 point system does not make provision for realistic prices, but rather for the best lowest price. Now, this is my question, Mr. Luderitz. If Mr. Reeder is correct, doesn't this mean that had the tender been lawfully adjudicated, it might well have been awarded to one of the tenderers who had submitted a lower price bid than the applicant, but who was disqualified on the basis that their price was too low? And this to some extent also ties in with the question that Justice Chikli had put to you.
Justice Strong, the answer is not a simple one, and I would need some time to offer a meaningful response, because what one needs to consider is, of course, the other tender criteria that was applied in the adjudication of the tender. By way of example, the CIDB grading, which required a minimum 8 CEPE grading, resulted in a number of tenderers being disqualified regardless of the price at which they tendered. So I would need some time to be able to respond to your question. It's not
Mr. Luderitz, it would be in order if you respond during your reply.
Thank you. The tender that you would, yes, I understand the point. I would need to reflect on that. Having
Mr. Luderitz, I'm just thinking, perhaps apply your mind to my colleague's question as you go along, and address us as fully as you want, maybe right at the end of your argument. My concern is that if you address the question in reply, then Mr. Mutipe may have to then respond to that argument after your reply.
Yes,
so just apply your mind as you go along. It doesn't matter that you require a lot of time to address it. We'll see how to manage that. But please address it before you end your submissions.
Thank you, Justice Malanga. I will ask my junior in the interim to consider the question more fully, and I will continue with my submissions. I may need to ask for a short adjournment just to confirm with it.
If it is not practical, then we may have to do what I was reluctant for us to do, which is that you address it in reply, and then we will have to give Mr. Mutipe an opportunity to respond to you. I don't know if you will then want to reply to that again. You know, it gets a bit cumbersome. That's why I was trying to avoid that situation. Yeah, but let's see what's practical. Let's see what's practical as we go along.
Thank you.
My sister, I'm not sure that you were done with your questions.
I am for now. Thank you, Justice Madlanga.
Thank you, my sister. Please continue, Mr. Luderitz.
Mr. Luderitz, may I take you to a matter that is, to me, bothersome, and it starts right at the outset. Two aspects of the trial before Makhoka J in the High Court. The first is your opening address. Am I correct that in your opening address before Makhoka J, you pertinently conceded that fraud and collusion was never found by the High Court or the SCA in the previous review proceedings?
Yes, I certainly conceded that no finding of fraud was made. And that was the extent of the concession that was made.
Yes.
And with respect, as Justice Goosen pointed out in his judgment, it is a concession that was correctly made because on a reading of the judgments of the Court Quo and of the Supreme Court of Appeal, a finding of fraud per se, and if I may interrupt myself, of course, a finding of fraud is a legal conclusion based on fact.
Yes.
But that legal conclusion was not made by either the Court Quo or the Supreme Court of Appeal. But that was the only concession that was made, and I will. It is helpful that you raise the issue with me because I think it's important that I take you to the opening address itself, given a submission by learned friends that we misled the court in our opening address by suggesting that the finding of fraud was in fact made. The record will show that there is no merit in that submission.
Yes, I have no problem with that. You need not take me there. That is not my concern. Having established that leads to my next question in this, and it is this. Notwithstanding that concession, am I correct that your case was still that there was misconduct on the part of the municipality as the administrator of this tender to the extent that it amounted to either dishonesty or mala fide or ulterior purpose or collusion or a mixture of all of that? That was still your case, notwithstanding that concession. I just want to establish that that is correct before I ask the third question, which is the one that bothers me.
Thank you for the question, Justice Majid. If I may offer, and please excuse me if I give a fairly comprehensive response to your question, but I think it's important that the record be set straight. First of all, as regards to what was said to the court in the opening address and what was not said to the court in the opening address. Now, forgive me for stating the obvious, but of course, the parameters of the dispute between the parties is informed by the pleadings. And if I may ask you to turn to volume 21, page 2068. In the opening address, well, perhaps I should just start at page 2067. I'm just mindful of the accusation that we misled the court as regards what was found by the court a quo. You will see in line 1 to 4, I make it very clear that the findings that were made against the municipality were bias, dishonesty, or various forms of impropriety on the side of the municipality. No suggestion that a finding of fraud was made. Then on page 2068, at line 20 to 22, we specifically draw the court's attention to the case as it is formulated in the pleadings. And we undertake to take the court to the pleadings. In paragraph 2, on page 2069, we raise the point, consistent with what was argued by the respondent, that there was no actual finding of fraud made, but we say that this does, as a matter of law, not absolve the municipality from liability. At page 2080, we again, without misleading the court in any way whatsoever, record verbatim the findings that were made by Justice Matujane at line 12, where we quote from paragraph 75 of the judgment, and drawing attention to the fact that the findings were made with that of bias, bad faith, and ulterior purpose. No misleading of the court whatsoever. At page 2083, at line 12 to 14, again, the findings were that of bias, mala fides, and dishonesty. We make the point that there was no appeal against those findings. Similarly, at page 2085, the second line of my address, the reference is to dishonesty, mala fides, and bias that were found by the Supreme Court of Appeal. And at the foot of page 2087, dealing with res judicata, we say at line 22, said, so there is no room, my lord, for evidence to rebut the findings of bias, mala fides, dishonesty. Then at page 2094, again the reference at line 11 to bias, mala fides, dishonesty. At the foot of page 2098, similarly, and at page 2099, in line 4, similarly bias, illusion, bad faith, and ulterior purpose. Then importantly, at page 2100, at line 13, we again specifically draw the court's attention to the case as it is pleaded. On page 2103, we draw the court's attention expressly to the pleadings, paragraph 25 of the pleadings, where, and this is of course the pleadings in the action, where specific reliance is placed on fraud. And that you will see from the paraphrased passage at line 9. There is a specific reliance placed on fraud, a specific reliance placed on corruption, and a specific reliance placed on fraudulent misrepresentation. The argument concerning fraudulent misrepresentation, of course, is developed in the pleadings themselves, where the case is that indeed the joint venture made fraudulent misrepresentations to the municipality, but those representations were to the knowledge of the municipality false. And then we say, and we submit quite correctly so, at line 12, the following: what in fact, my lord, was found by the SCA is at least bias and dishonesty. It is correct that no finding was made of fraud or corruption. But, my lord, we say that on the law, it is not necessary to go that far. And then what follows is a debate with his lordship about the legal principles and the two opposite ends of the scale that informs whether there is liability or not. Is it an innocent and bona fide mistake, or is it something different to that? And in that context, we have a legal debate where we say, to our mind, it is not even necessary to find fraud, anything other than an innocent or bona fide mistake, consistent with Gore, Steenkamp, and other authorities, is something that would give rise to liability.
Mr. Lutheris, I think you have amply answered that question. So let me get to the question that bothers, aspect that bothers me in the interest of time. You chose before Makoka J to rely on the affidavits as they stood in the review applications, and you are criticized for that. And some of the findings in the SCA, for example, by Nichols J and Poedlwati AJA, criticize you for that because they say they hold that you did not prove the case that you brought in respect of damages. What is your response to the allegation by the respondent that nowhere in those affidavits, and I mean we can go to the passages if need be, but generally speaking, they submit that nowhere in those affidavits by Mr. Gibbons does he allege fraud or collusion as a ground for review under PAJA. You'll recall that there are two grounds listed in the affidavit in the second urgent application for an interdict, and in the affidavit for the secondary review application, there are 8 grounds listed. They say none of them cite under PAJA fraud or collusion, etc.
Justice, if I can answer the question as follows. First of all, the question, of course, was whether it was necessary to establish fraud in order to succeed in the review application. It was not a necessary requirement, and we repeat with respect that all of these findings, whether it is fraud, bias, collusion, mala fides, or ulterior motive, are all legal conclusions that are drawn based on fact. And the important question we submit is whether the facts, as they are recorded in the affidavits, in fact warrant any one or more or all of those legal inferences. In the context of the review application, both the court a quo and the Supreme Court of Appeal concluded that the facts, in fact, demonstrated bias as a substantive ground of appeal, of review, my apologies, mala fides, and dishonesty on the part of the municipality as sufficient to support the review and setting aside of the award of the tender by the municipality. Based on an application of Plascon Evans and accepting that there was, in certain respects, a contrary version offered by the municipality in its answering affidavits, those conclusions were made notwithstanding by the Court Quo and the Supreme Court of Appeal. What is then presented to the High Court in the damages action is the version of the appellant on an uncontested basis. The affidavits of the respondent are not placed before the court by the respondent as offering a counterfactual version. So what is placed before the court is the version of the appellant, but this time on an uncontested basis. The respondent is offered the opportunity of cross-examining every deponent to every affidavit in the review proceedings. The respondent elects not to cross-examine any of those witnesses, elects not to present a counterfactual version to any one of those witnesses, and equally elects not to call a witness that it had identified as someone that it would have called in the proceedings. And I was at pains to make sure that there is absolutely no misunderstanding about the basis upon which the evidence is presented to court, lest there was an argument, as we now see in our learned friends' heads of argument, that these affidavits were simply placed before the court as affidavits that served in the review proceedings. The affidavits were placed before the court as evidence and uncontested evidence in the proceedings. And if I may invite the court again to the opening address at page 2143, I address the court at line 16. And at line 19, I say the following. The findings that were made by His Lordship Justice Matujani, to the extent that they were not overturned by the Supreme Court of Appeal, it should read are, not of, are findings that were made against the first defendant. No findings were made against the plaintiff. But that is a topic, my lord, that we can debate at the conclusion of this matter. Perhaps the more pressing issue, my lord, to deal with, at least in an attempt to expedite the hearing, my lord, is the issue of evidence. What I can tell your lordship, my lord, and it appears also from our opening address, that we intend calling every witness that deposed to an affidavit in the review proceedings and in the ancillary interdictory proceedings. My lord, that served before various judges at various times in the proceedings that ultimately culminated in the review and the appeal. The purpose of their evidence would merely be, my lord, to confirm the correctness of the statements that they made on oath, and of course to identify their signatures in the documents so as to constitute evidence in these proceedings. If my learned friend has no intention of cross-examining these witnesses, and if he is prepared, my lord, to admit those affidavits, my lord, then I can tell your lordship that we have nothing to add to the body of evidence that we intend placing before the courts. Then my learned friend responds, Mr. Mukari, at line 20, and at line 24, he says, so those affidavits stand as affidavits as evidence, which was before the court, and they are accepted as such. And to remove any possible doubt, at page 2145, At line 5, I then say to the court, yes, my lord. So if my understanding is correct, my lord, then those affidavits then stand as evidence in the proceedings before your lordship. And the court says, yes. So the evidence was placed before the court on an uncontested basis. The respondent not having made use of the opportunity to cross-examine, not made use of the opportunity to offer a counterfactual version, and not making use of the opportunity to lead evidence in rebuttal of any factual version offered by the appellants in the various sets of affidavits. And we submit, Justice Majid, that approach with respect cannot be criticized. It would have served no purpose to call the witnesses simply to read into the record their evidence, or on a question and answer basis to simply repeat their evidence in circumstances where the respondent had indicated that it doesn't require the opportunity to cross-examine on any factual matter contained in the affidavits.
So just to conclude, my part of the question then is, your case then is that based on these affidavits, taken together with the findings of Matojane J, as confirmed by the SCA in the Van Zyl AJA judgment, which was a unanimous judgment, you say that there is sufficient evidence of bias, bad faith, and ulterior purpose to have proved your case. That is the conclusion.
Indeed so. And then, of course,
Yes,
it is open to this court, as it was open to the Supreme Court of Appeal, to draw the inference whether or not there was fraudulent and dishonest conduct on the part of the municipality. The approach taken by Justice Goosen, which we support, is that he finds that fraud lies in the fact that there was a deliberate and intentional subversion of the prescripts of Section 217 of the Constitution, and that indeed is in fraudem legis, and that you will find in paragraph 66 on page 2335 of the judgment of the Supreme Court of Appeal.
Justice Madlanga.
Thank you. Mr. Luderitz, while we're dealing with the findings of the High Court and the SCA in the review proceedings, does the rule in Hollington versus Youthorn not preclude us from relying on those findings?
Justice, we would say not. We would say, well, let me say two things. First of all, it is not, strictly speaking, res judicata, because of course it's not the same subject matter. It is perhaps more a matter of issue estoppel. But the more important point is this: the body of evidence that on an application of Plascon Evans, and having due regard to a counterfactual version offered by the respondent, enabled the High Court and the Supreme Court of Appeal in the review application to make the findings that it did. The body of evidence that has been placed before the court, I quo, the Supreme Court of Appeal, and this court in the damages action is far more compelling than the evidence that was placed before the review courts. And that is so for the simple reason that the body of evidence that has been placed before this court in support of the damages action is there on an uncontested basis. So whether one reflects and considers oneself bound to the findings that were made by the High Court and the Supreme Court of Appeal in the review application, or whether one simply independently assesses the evidence as it has been placed before the court in these proceedings.
Let's separate the two, if we can, Mr. Luderitz. Let's separate the assessment, the independent assessment of the evidence by this court, and let's look at the question, or can try to answer the question, whether this court can rely on the findings of the High Court and the SCA.
We would submit that the findings as they were made are binding on the respondent. The respondent, you may recall, pleaded that those findings...
Let me put the question differently, Mr. Luderitz. Are those findings binding on this court in these proceedings?
It is certainly binding on the respondent in these proceedings. The respondent accepts that the findings are binding on it in these proceedings. As between the parties to this proceedings, it is common cause that those findings were made, that they are unchallenged, and that those findings are binding on the respondent. That was the respondent's pleaded case. That was repeated in the respondent's opening address, and the matter proceeded on the basis of an acceptance on the part of the respondent that those findings are common cause between the parties.
Mr. Luderitz, I just want to find out something about the claim. We know that the applicant launched review proceedings to review the action of the municipality under PAJA. And PAJA makes provision for one to claim compensation. Yet the applicant sought to proceed by way of intellectual action. Is that allowed?
We submit that it is most certainly allowed. The authorities that we have cited in our heads of argument, Gore, Steenkamp, Olitsky, we submit support the entitlement on the part of the appellant to pursue a private law remedy against the municipality, assuming that it can establish the grounds of delict relied upon by the appellant, and the fact that as part of a public law remedy, compensation could be considered to be a just and equitable remedy does not disallow a claim for damages in terms of a private law remedy. The matter was specifically considered in the Simca Trust matter that we referred to in the application for leave to appeal, the affidavit deposed to by Mr. Van Zyl in paragraph 52 on page 2301. When one considers a public law remedy, including a remedy to offer compensation to an unsuccessful tenderer, one does so mindful of a whole host of considerations as they were appropriately identified in this particular case in the judgment of the Supreme Court of Appeal when it granted the relief that it did. And where the interests of the community and a number of other broader interests are considered in determining what would constitute a fair and equitable remedy. And if we may offer to the court the relevant passages of the judgment of the Supreme Court of Appeal, that would be found in numbered paragraph 21 on page 272, paragraph 22, 23, 24, where, if I may draw your attention, the court said, in the context of an unlawful tender process for the acquisition of goods and services for the benefit of the public, the finding as to an appropriate remedy must strike a balance between the need for certainty, the public interest, the interest of the successful and unsuccessful tenderers, other prospective tenderers, the interest of innocent parties, and the interest of the organ of state at whose behest the tender was invited. So in considering what would constitute an appropriate remedy in the public law context, a number of other relevant considerations would inform the question whether or not it would be appropriate to grant compensation or not. Returning to the facts of this particular matter and to answer your question.
Just to add to my question, we know that in this matter, the municipality has had to pay the other contractor, Varanani, I'm not sure if I pronounce it correctly, millions of rent to complete the project. The applicant is claiming millions as well for loss of profits. What about public policy considerations? If you had claimed under PAJA, surely the amounts claimed would not have been as high as what is sought now. That's what I would like to know. I know that quantum is not before us, but I think it's an issue that one has to consider. The public policy considerations, because the municipality, actually, if you are successful, will have to pay twice, you as the applicant, as well as the other party that has been, that had performed the services.
Justice Mtlanta, I'm not sure that it is correct with respect to say that the municipality would be paying twice. The question is with respect, what is the municipality paying for? The municipality is paying the tenderer, the successful tenderer. This is now following the process prescribed by the Supreme Court of Appeal following the setting aside of the tender. The municipality is paying for two things. It is first of all paying for the cost of the remedial work necessary in order to correct all of the adequately performed work that were performed by the joint venture. So the first part of what is being paid to the new tenderer is the cost of remedial work. The second part of what is being paid to the new tenderer is the cost of completion of the work. The claim that is asserted by Esorfranki is not for payment of work that it is not to undertake. What Esorfranki seeks is the loss of profit that it would have earned had a legitimate tender process being employed, and had it not been denied the right to make a profit through the dishonesty of the officials of the municipality. So it is two different payments with respect that one is considering, and we say that again, with respect, one must not conflate the public law remedies that are offered following a review of a tender process with the private law remedy that a party either can or can't establish based on the ordinary principles that apply to claims based in dealing.
Mr. Luderitz, if my sister has finished, I wonder whether I may ask you something flowing from...
Well, the last question was going to be...
sorry.
My last question relates to, it also could be something that will be determined by the court dealing with quantum. But I just want to know, from the record, it appears that the applicant has managed to get 5 million from the joint venture by way of default judgment. Should the court have regard to that issue when considering the public policy considerations of the applicant's claim before us? That's my last question. Thank you.
Sorry.
Justice, the extent to which the appellant is to be compensated for the loss that it had suffered is a matter that will be determined as part of the quantification of its claim. And in assessing the quantum of its claim, the court will always be guided by two fundamental principles. The first is that there is a positive duty on a party seeking to claim damages to take steps to mitigate its damages. And mindful of that consideration, you will recall that the appellant's claim is formulated on two alternative bases. The first formulation contemplates that it is somehow successful in the third attempt to regularize this tender process, and that in doing so, it is able to make a profit on the project. The alternative basis is that it is not able to mitigate its damages in that manner, and then it offers an alternative formulation. So that would be the first important principle that would always guide a court in determining the quantum of the claim of the appellant. But secondly, of course, is the concept of double compensation. And to that end, and to the extent that the appellant is able to recover some of its damages from a third party who colluded with the municipality in unlawfully denying the appellant its right to make a profit on the project, that will most certainly be taken into account in the quantification of the appellant's claim. So
Mr.
both,
Luderitz, in the interest of time, could I just ask you a follow-up question, which is this: when one considers the relationship between public law remedies and private law remedies, the effect of bringing a review is to set aside the tender process and hence to expunge the illegality with which that process was infected. If a litigant chooses the public law remedy, the effect of the review is to expunge the illegality, and then you can start again and participate in a new tender process. How does one retain a private law right and a showing of wrongfulness when you have exercised a public law right to expunge the very illegality that you have to then rely upon in the private law realm?
Justice,
before you respond, Mr. Luderitz, your 1 hour is up. How much more time do you want? I know, of course, we've been interrupting you, but on your own estimation, how much more time do you think you want?
Justice Madlanga, I have not made, as I intended to do, submissions in response to the arguments advanced by our learned friends in their heads of argument thus far. I have been responding to questions put to me by the bench. In doing so, I of course have dealt to a certain extent with responses that we would have offered to arguments advanced by the respondent, but I still need to make some submissions in relation to arguments advanced by learned friends.
And your estimation, how much time do you want?
I would
for purposes of control.
I would imagine that I would need at least 30 minutes to make submissions in response to arguments advanced by learned friend.
Just thinking, you said you have dealt, have you dealt with only some, or do you think you've dealt with all of them, albeit perhaps haphazardly, because it's in response to a question there and in response to a question there?
I've certainly dealt with a number of issues raised by a learned friend, but I would need to take stock of what remains, but we will confine our arguments
Yeah, I'm asking because it's just it's the nature of the game here. You come, thinking that you're going to structure your argument this way, but you end up presenting it haphazardly because you argue different points as and when we put questions to you. And after it all, you see that I've basically addressed everything, even if not in the order in which I would have liked. That's something you should just live with. 30 minutes seems a bit long to me. Let's say 20 and see how it goes.
Thank you, Justice.
20 starting now, which will be what, 11:23.
Yes, perhaps I can just answer the question of Justice.
Perhaps just respond to my colleague Justice Unterholter's question, and after that response, don't proceed to a new point. We will take the tier adjournment that will then give you an opportunity to apply your mind to my sister Justice Theron's question. And when we resume, you then take your 20 minutes.
Thank you, Justice.
Please respond to my brother Justice Unterholter.
Justice Unterholter, again, if I may go back to the considerations that informed the appropriate remedy as they were recorded in paragraph 24 of the judgment of the Supreme Court of Appeal. Now, why this is important is because fundamental to the question that you have put to me at a factual level is, of course, the delay in the adjudication of the review process. When the review process was launched, it was launched on an urgent basis with the intention of precluding through various interdicts the continued execution of the tender so as to ensure that if the appellant prevails in the review process, that it would be in a position to undertake and complete the tender as it was initially intended to be awarded to the successful party. As a consequence of the plainly dishonest conduct on the part of the municipality, you are aware of the fact that numerous applications for interdicts were brought. There were applications made for leave to appeal. There were.
I'm completely aware of what happened in this matter and the need to fashion an equitable remedy in the light of the conduct of the municipality. But my question is of a more conceptual kind, which is when you bring a public law remedy in review, the effect of it is to expunge the illegality. You set aside the tender process, and then you consider what the right remedy is. But the effect of that correction, in other words, the restoration of legality, is to expunge the very wrongfulness that you rely upon in the private law claim in delict. And that's why you can't have it both ways. And it's reflected in your pleadings, because how can you have a situation where you are potentially able to participate in a new tender, which is the remedy for the illegality of the old one, and simultaneously retain a right to claim loss of profits in delict? It's a contradictory stance, and it has everything to do with the problem of wrongfulness rather than the problem of remedy. But you might want to think about this during the adjournment, because I would certainly be interested to hear your response on that score.
Justice Unterholter, the question is with respect, well, our learned friends rely on the judgment in Steenkamp and advance an argument that the alternative process, the alternative tender process, in fact, offers a clear remedy.
Mr. Luderitz, don't you want to take up the offer to consider this during the tier adjournment?
Thank you, Justice.
Yes.
Justice Madlanga. Justice Madlanga, if I may please to ask Mr. Ludertz to consider a further aspect to the point I raised earlier and that he was going to respond to, please. Mr. Ludertz, given the irregularities in the tender process, how can we conclude that the other tenderers who were disqualified were rightly disqualified? Perhaps put differently, I'd raised with you that some tenderers were excluded because their bids were too low. How do we know that's a valid criteria or a valid basis upon which to exclude tenders? Thank you, Justice Madlanga.
I can perhaps respond to that before the tea adjournment.
Let's rather take the tea break and resume at 11:23 on the dot. Court adjourned.
Thank you.
Justices of the Constitutional Court or counsel are online.
Justice Madlanga is muted.
Thank you, my brother, Justice Nwamba. Mr. Luderitz, I have reconsidered the position. I'm thinking you had 3 questions to consider during the break, and you said the issues you still want to consider, issues raised by your opponent in their written submissions. Let me just give you the 30 minutes starting now. Please, please present your argument.
If I may respond to the question that was raised with me by Justice Tron first. I was referred to page 438 in volume 5, and specifically the passage in paragraph 6, recording that it is considered that the project cannot be effectively completed for less than 201 million rand, and that any tender or less than this amount will not be cost effective, and such tender is not an acceptable tender. And the question was whether there are other potential qualifying tenders that were excluded on this basis. If I can refer the court to volume 4 at page 410. Page 410 contains a list of the tenders that were submitted, and it assesses the tenders with reference to the CIDB grading, and assesses whether or not any particular tender complies with the minimum grading requirement. If one considers that list, then one will note that only the following tenders qualified as having an acceptable CIDB grading, and those are tenders number 6, 7, 8, 15, 16, and 18. And all of those tenders are for amounts in excess of 201 million rand. So it appears that there was no qualifying tender that was excluded on the basis of what is recorded in paragraph 6 on page 438. I may then also point out that on the pleadings, it was common cause that the tender of the plaintiff was the lowest priced acceptable tender. And that allegation is made in paragraph 30 on page 26 in volume 1. And it is admitted by the respondent in an answer to a request for further particulars appearing at page 290, paragraph 16.2. If I may then deal with the question that was put to me by Justice Unterhalter. What was put to me is that the remedy that was carved out in the review proceedings, namely a review and setting aside of the tender, the declaring of the contract as a nullity on the basis that fraud unravels all, and a re-advertisement of the tender, in fact, expunged the illegality that now seeks to inform the private law claim for damages. In the short time that we've had to reflect on the question, we started by considering what would be the meaning of the word expunge as it is used in what was put to me by Justice Unterhalter. The dictionary defines expunge as erase, remove completely, or to cause something to be forgotten. In that context, we say that the remedy that was carved out by the review court on a consideration of all of the relevant factors identified in that judgment, whilst it did address the unlawfulness of the tender process, it, with respect, did not expunge the wrong that was perpetrated on the unsuccessful tenderer, nor did it expunge the consequences of the wrong. The consequences of the wrong lies in the fact that a party that would otherwise have been entitled to execute the tender, who would otherwise would have been entitled to make a legitimate profit on the project, was denied the right to do so in flagrant breach of the Constitution, dishonestly and deliberately so by the municipality that was...
Mr. Ludwig, excuse me, sorry to interrupt you. Is this your argument that the wrong that was allegedly perpetrated continued ad infinitum? In other words, from the first tender that was set aside, the second tender, even if there was a third tender, that wrong would still have continued to afford Esorfranki the right to claim delictual damages?
The wrong in our submission, Justice Matopo, occurred, and the wrong had certain consequences. To answer your question, we submit with respect.
Sorry, before let me interrupt myself and you as well. On Esorfranki's stance, when did the wrong occur? Did the wrong occur during the first tender, or the wrong occurred during the second tender, or prior to the first and second tender?
The wrong occurred when Esorfranki was unlawfully denied the right to execute the tender, to perform the work, and to make a profit on the execution of the work. That's when the wrong occurred. Esorfranki sought to address the wrong, firstly by instituting review proceedings with the intention of immediately interrupting the continued execution of the fraudulent tender and ensuring that it is placed in a position where it could continue to execute the tender that ought to have been awarded to it in the first place. As a consequence...
Sorry, I'm going to be interrupting you, but pardon me, it should be the last. Is that your contention that an unsuccessful tenderer can institute review proceedings, as in this case, to set aside the tender while retaining in its pocket the right to sue for damages as in the private law remedy, as a private law remedy? Throughout, it has that option.
Well, we say that this is a good example of the fact that that this indeed is legally permissible, and the reason why we say that, and again, the facts of this case are important in addressing the question that you put to me, because what Esorfranki does is it launches immediately and without delay review proceedings it launches a number of interdictory proceedings to stop the execution of the tender, so as to avoid the very situation that the municipality sought to engineer, and that was to execute as much of the tender as possible, as quickly as possible, so as to enable the municipality to argue, as it did throughout up to the Supreme Court of Appeal, that the tender had been fully executed and that there would be no point in setting aside the award of the tender. So it then becomes, as a consequence and as a direct consequence of the continued deliberate dishonest conduct on the part of the municipality, an exercise in futility for Esorfranki to seek to be awarded the tender. We're not talking about the tender that the Supreme Court of Appeal ultimately directed the Department of Water Works to oversee, a tender that was aimed at remedying the work of the joint venture and of completing that which remained outstanding. That's not the tender that Esorfranki submitted and competed for in the first place. So when that reality arises, Esorfranki is left with a claim for damages, and that claim arose when it was denied the right to participate in a lawful administrative process as contemplated by Section 217 of the Constitution.
And when was that? Excuse me, when was that when it was denied that opportunity? Was it the first time or the second time?
Well, if you're referring to the first time, Justice
sorry, Mr. Luderichs, I just want to know from you, when was that when Esorfranki was denied that opportunity? Was it the first or the second time?
It was denied. It was denied that opportunity it was unlawfully denied that opportunity on 2 occasions. On the first occasion, Esorfranki went to court and obtained an order through Justice Preller, setting aside.
I have read the papers. I have read the papers. I know the whole history about it. So when the first tender was set aside, if I understand your argument correctly, what you want us to accept is when it went ahead and submitted another tender, it still retained its right to sue for delictual damages.
No, but with respect,
that's where I want to understand you now.
Yes, if I may answer, one needs to draw a distinction between whether there is a cognizable cause of action and whether damages have arisen as a consequence of a particular action. In the first instance, when Esorfranki is denied unlawfully the right to be awarded the tender, and it turns to the High Court, and the tender is set aside by Justice Preller, there was a wrong that was perpetrated on Esorfranki. Esorfranki didn't elect to pursue a claim for damages because at that time, presumably, it didn't consider itself to have suffered any damages, and it was hopeful that the wrong that had been perpetrated on it would be remedied through the award of the tender to it. When that does not happen, and for the second time the tender is awarded to the joint venture, the wrong is perpetrated. The moment that the tender is awarded to the joint venture, Esorfranki is unlawfully denied the right to execute the tender. it hasn't suffered any damages at that point in time. It then seeks to address the harm and the unlawfulness through a review application, the purpose of which is to ensure that the tender, as it was originally formulated and to which it was originally entitled to, be awarded to it. That does not happen. It does not happen as a consequence of the continued unlawful and dishonest actions of the municipality. But the fact remains that an unlawful act had been perpetrated on Esorfranki. It suffers damages as a consequence of that unlawful act. It retains as a positive obligation a duty to mitigate its damages. It does so by participating in a different tender process in an attempt to mitigate its damages, and it recognizes in its particulars of claim that if it is to be successful in so mitigating its damages, that would reduce the quantum of its claim arising from the initial wrongful act that was perpetrated by the municipality. But one needs to draw a clear distinction between the unlawful act itself and the damages that flow from the unlawful act. So it is notionally, of course, possible that a review process may result in the fact that an unsuccessful tenderer doesn't suffer any harm if the intervention is expedient and effective, and the joint venture was precluded from executing the tender, and Esorfranki could timely have been substituted as the successful tenderer and could have executed on the tender, then that would have addressed the damages that would have been suffered by Esorfranki. But it does not expunge or obliterate forever from the records the unlawful act that was perpetrated on it. It is the consequences that now become of lesser significance.
If my brothers are answered, can I just, Ms. Madlanga, through you, just make a follow-up to an earlier debate with Mr. Ludwig, and the question that was posed to him by Justice Theron, just to tie.
Just as I see my brother Justice Unterholter's mic is still on. Were you done, my brother?
No, not at all. Thank you. I've done.
Oh, thank you. Yes, my sister, please proceed.
Thank you. Mr. Ludwig, I'm trying to establish the proximity between the alleged wrongful act and the loss you say was suffered by Esorfranki. And so my question really talks to that. Earlier during our debate, you said that Esorfranki would probably have been successful. To what extent is it relevant at all, if at all, that when the tender to do the remedial work was open, Esorfranki did not succeed?
Justice Chiki, I'm not sure whether I have a bad connection, but I couldn't hear the full question that you posed to me. I understand that you're referring to the fact that Esorfranki was unsuccessful in the later tender, and
yes.
I'm not sure that I couldn't hear the full question that was put to me. If I may ask you to repeat it.
I'll do so. I'm saying that my question pertains to the proximity between the wrongful act and the loss that you allege was suffered by Esorfranki. And I then refer you to the earlier debate we had and which you had with my other colleagues, where you said that Esorfranki would probably have been successful, right? And I'm asking, to what extent do we take into account the fact that when the tender for the remedial work was out, Esorfranki was still not successful. Instead, it was awarded to Varanani.
The loss, to answer your question insofar as the proximity is concerned between the wrong and the loss, first. The wrong is the fact that Esorfranki is denied the right to execute the tender. As a consequence of that unlawful denial, it is denied the right to earn a profit on the execution of the tender, and that is the loss that it suffers, and that is the loss that it claims from the municipality consequent upon the wrong that was perpetrated. The tender for the remedial work has a bearing, we submit, on the question whether or not Esorfranki, first of all, had an obligation to participate in the new tender as part of its duty to mitigate its damages. And if it was unsuccessful, well, if it was successful in obtaining that further tender, to what extent that has to be taken into account in the quantification of its claim against the municipality. And if it has been unsuccessful, whether it can say that it took all reasonable steps to mitigate its damages. But we say at a factual level and at a legal level that the further tender doesn't constitute what our learned friends describe as an alternative remedy. It's not an alternative remedy at a factual level because, as Justice Goosen, we submit, correctly pointed out, the tender was a very different tender. One of the reasons why the Supreme Court of Appeal in the review application did not award the tender to Esorfranki, in other words, why it did not substitute Esorfranki as the contracting party to execute the original tender, was in fact the uncertainty about the extent to which the original tender had been executed. The Supreme Court of Appeal made reference to the judgment of the High Court when it considered the question of what would constitute an appropriate remedy, where the High Court legitimately raised concerns at a practical level about the extent to which work had been executed, issues regarding severability, issues regarding ownership of plant and equipment that was used in the execution of the tender process. But if you consider the judgment of the Supreme Court of Appeal in the tender process, then it is
Mr. Lutritz, I think that have been covered. I don't want really to take out much of your time that have been afforded by Justice Madlanga. I mean, your first response responded to what I asked. Whether I accept it or not is another issue. I also want to take you to public policy considerations that you debated with my sister, Mhlandla. And I'm interested to know to what extent should we take into account this court, meaning the sentiments that were expressed by Mathojan and J concerning the KZN case, the involvement of Esorfranki in the KZN case. You will find those in page 77, paragraph 51, I think.
Yes, Justice Tiki,
and my question relates to the involvement of your client there and whether they are approaching this court with clean hands.
Well, Justice Tiki, again, first of all, at a evidentiary level, there is no evidence to that effect that has been placed before the court in these proceedings to warrant that inference. The municipality has elected to accept the uncontested version of the appellants as it is set out in the affidavits that have been placed before the court. And in these proceedings, they've elected not to place any counterfactual version in support of that notion before this court. The last word that was spoken on this topic was indeed not His Lordship Justice Matujane, but the Supreme Court of Appeal itself. In paragraph 29 on page 276 in volume 3, the Supreme Court of Appeal, dealing with the issue that you have raised with me, said the following. The findings of the High Court that the parties were to pay their own costs in respect of the relevant applications were essentially made on the basis of what the court described in its judgment as the unreasonable and unconscionable manner in which Esorfranki and its attorney, including SICAD, conducted this litigation. It found that the appellants made themselves guilty of collusion. That finding is not supported by the facts. Esorfranki and SICAD are separate legal entities. They separately submitted tenders, instituted legal proceedings, and instructed separate firms of attorneys to act on their behalf. The mere fact that they were the joint beneficiaries of a tender awarded to them in another province, and that there may have been similarities in the papers filed by them in the present proceedings, does not support a finding of collusion, the import of which, after all, is the presence of dishonesty. There is nothing untoward in one litigant aligning itself with another and cooperating in the quest to achieve a particular result in legal proceedings. So that was the last word with respect that was spoken by the Supreme Court of Appeal on the finding that was made by Justice Matujane. Significantly in the context, of course, of him considering an appropriate order as to costs.
Thanks, Justice Matlan.
Thank you. Only 3 minutes is left in the 30 that I afforded you.
May I conclude?
Yes,
Sorry.
yes, Mr. Lewis.
I've still not dealt with our learned friends' heads, but perhaps I can deal with that in reply. Perhaps I can conclude by referring the court again to the judgment in Gore. Gore, of course, is a case where there was a review application. Following the review application, there was an action that was instituted for damages in delict, an action that was determined in favor of Gore. Mr. Gore, the court may be reminded, of course, acted in his capacity as a liquidator, the unsuccessful tenderer in that instance having been liquidated. So if one considers the question that was put to me by various members of the court, and one assumes facts or a scenario to the effect that the unsuccessful tenderer, who is now denied the right to execute the tender and to make a profit, as a direct consequence of this unlawful action, meets financial ruin and ends up in liquidation, meaning that it would have no capacity as a direct consequence of these unlawful acts to participate in any future tender process. Would that mean, we ask rhetorically, that tenderer would have no claim for damages simply by reason of the fact that a court, in discerning what would constitute an equitable remedy, weighing up all of the relevant considerations as they were spelled out in the judgment of the Supreme Court of Appeal, concludes that the best way forward is to re-advertise the tender. We submit with respect that is not something that will be countenanced by the legal convictions of the community, and that the question whether or not the tender is re-advertised and the previously unsuccessful tenderer is successful in achieving now on a third attempt the award of the tender is something that does not bear on the question whether the initial act was lawful or unlawful, and whether it gives rise or does not give rise to a cognizable claim, but really bears on the question whether or not a party who had been denied the right to execute and who had suffered damages was able to mitigate its damages through participation in a further process.
This is the terminal point, Mr. Luderitz.
Thank you, Justice. Those are our submissions. Perhaps if I can conclude by simply offering the court the references in the two passages in Gore, paragraphs 87 and 88, which deals with the convictions of the community in circumstances where there is a deliberate, dishonest conduct on the part of the administrator.
Thank you very much.
Justice Malanga, please may I seek an indulgence to put a final question to Mr. Luderitz. I know we've taken much longer than anticipated. Mr. Luderitz, what do you say to the argument presented by the respondent, which endorses paragraph 98 of Justice Nichols's judgment, where it's held that once the original tender was set aside, it becomes void ab initio? How do we reconcile that argument with the principle of abstract constitutional validity?
Justice, I'm not sure with respect that I understand the question. I think the question is perhaps similar to what was put to me by Justice Unterhalter.
Yes, it does relate to that, yes.
In the context of whether the wrong has been expunged, to use the words of the learned judge.
Yes. And perhaps if I can go one step further to try explain, the unlawful conduct would have occurred, or the illegal act would have occurred when the conduct happened. And a declaration by the court simply declares that it is so.
Yes.
Yes, perhaps you can respond.
Yes, but the court doesn't say that it never happened. It says that it happened and it was wrong. And it says we are now obliged under the Constitution and under PAJA to carve out an appropriate remedy that is just and equitable, and which is informed by a plethora of considerations. And we need to take account of the fact that ultimately this pipeline was supposed to provide desperately needed water to a desperately poor community. And how do we go about to achieve that objective in the interest of the community best? And recognizing that in doing so, it does not necessarily address the harm that was perpetrated on the unsuccessful tenderer, but says the court in carving out an appropriate remedy, Mr. unsuccessful tenderer, I cannot accommodate in my remedy the harm that was perpetrated on you, because the harm that you suffered is but one consideration that I need to take into account. Ultimately, I must make sure that the desperately poor get desperately needed water as quickly as possible. And that primarily informs the remedy that I then carve out. Pursue your claim for damages against the municipality if in fact in delict and accepting the convictions of the community, it is considered appropriate that a municipality that has dishonestly and deliberately denied you the right to make a profit, and that has dishonestly and deliberately denied you the right to participate in a process that is constitutionally endorsed by Section 217, pursue the municipality privately for the damages that you contend you have suffered and that you can prove you have suffered, accepting that you cannot make a double recovery, accepting that you have a positive duty to mitigate your damages.
Perhaps in fairness to you, Mr. Luders, I should give you an opportunity to refer to paragraph 98 of the SCA judgment, because it also relates to the point that Justice Unterhalter made and whether that conduct is expunged. And if it is expunged, whether the applicants can still pursue delictual damages. Because the SCA judgment says that once the original tender was set aside, it became void ab initio. Now the question is, conduct that is void ab initio, can it attract delictual liability? And I think you have gone some ways in answering that.
No, but with respect, there are two steps. The first one is the review and the setting aside of the tender. That is relief that was...
Sorry, Mr. Ludwig, let me direct you to what my question is. Do you agree with what was held by the SCA?
But Justice, you're referring to the passage in the judgment by Justice Nichols.
Yes, I am. Yeah. And do you agree, or what? That is the nub of my question.
No, we don't agree.
Yes, and I want to know, why don't you agree?
We don't agree because the learned judge does not draw the distinction. That
Sorry, before you answer, would you say that that's a mistake of law that was made in that judgment by the SCA?
Yes, we would say that that is a mistake. It's a mistake of law. It's an incorrect application of the law. One needs to draw a distinction between the reviewing and the setting aside of the tender and what would then constitute an equitable remedy. So if we go back to the judgment of the court, I quote, in the review proceedings, the court upheld the review, but in discerning a just and equitable remedy did not set aside the contract. The harm does not flow from the contract that was declared void. The harm flows from the fact that the tender process was non-compliant, and deliberately so, with Section 217 of the Constitution. So when the contract is declared void, then that bears on the private relationship between the joint venture and the municipality that was brought into life by the contract. Because that contract was vitiated by fraud, and because fraud unravels all, the contract was set aside. But the harm that was perpetrated on Esorfranki is concerned with the unlawful tender process, where in flagrant disregard of the constitutional imperatives, it was denied the right to conclude a contract with the municipality and to execute the tender following a lawful award of the tender to it. So there is with respect, a disconnect between the declaration of invalidity of the private law contract and the claim for damages that Esorfranki asserts by way of delict.
Thank you. Thank you, Mr. Dudrich. Thank you, Justice Mhlanga, for the indulgence.
Thank you, Mrs. Thank you, Mr. Luderitz. Mr. Mutipe.
As the court pleases. Justice, firstly, I listened to exchanges and submissions by my learned friend. And there seems to be a conflation of what has been found on the facts with regard to fraud. Because whereas he correctly says the SCA found that fraud unravels everything. But what fraud was found by the courts? And that's the first question. And one must bear in mind that we're not longer dealing with motion proceedings, we're dealing with an appeal from a trial. And one must therefore look at what is it that the applicant pleaded in his particulars of claim. And we say in our heads, the first statement we made is that when one alleges fraud, it's got to be alleged distinctly and proven distinctly. Now, I want to refer quickly to various paragraphs of the particulars of claim, just to indicate that the fraud that was alleged and ultimately proven is the fraud by the joint venture on the municipality. That is the finding of Matujani J. That is the finding of the SCA. In other words, none of them find that there is fraud perpetuated by the municipality. And my learned friend argues the two are conflated, and that we submit is incorrect. One has got to be very careful. And if I may then refer to paragraphs 13.8 to 13.13 of the particulars of claim. This is in volume 1, it's pages 9 to 10.
I trust that colleagues have not forgotten that Mr. Mutipe waived the 10-minute protection. Please continue.
Yes. Justices, if one looks at these allegations, here the applicant specifically pleads that it is a joint venture that perpetuated fraud. In paragraph 13.9, it goes further. It says the joint venture perpetrated various frauds on the first defendant. And that is important. It continues along those lines to make it clear that it is fraud by the joint venture on the municipality. At paragraph 18, and that is, by the way, in relation to the first award. At paragraph 18, it deals with the second award of the tender, and then it says, the very same improprieties referring to fraud that was committed under the first award were again committed in the second award. So it refers to paragraph 13 again.
Mr.
So that if
Matipa,
one, yes, ma'am.
excuse me, I'm sorry to interrupt you. But it may well be, or let me put it this way. Is it your submission that absent a finding that the municipality acted fraudulently, it cannot be held liable in delict?
In the circumstances of this case, yes, it is my submission.
But that submission runs contrary to what Steenkamp and what Gore says. And I refer you in particular to paragraph 55.1 of Steenkamp, where this court said, if an administrative or statutory decision is made in bad faith or under corrupt circumstances, or completely outside the legitimate scope of the empowering provision, policy considerations must justify the imposition of delictual liability. There's no mention of fraud, Mr. Mutip.
Justice.
And for a minute, let's forget about the facts of the case. Let's talk about the legal principle. and the principles that emerges from the cases?
Yes, Justice, my answer is quite simple. If one establishes, say, bad faith or bias under Section 6 of PAJA, it goes no further than that. It is different to a finding that is going to be made in a trial where dishonesty is established. Terms like bad faith, all those that we find under Section 6 of PAJA. In my submission, it does not qualify as a finding of bad faith that would amount to corruption or that involves dishonesty. It may just be that the courts have found on motion proceedings. They have found that—
Mr. Motepe, the submission that you're making runs directly contrary to the passage of Steenkamp that I've just quoted to you.
My lady, as Justice, as I understand the authority in Steenkamp, it related mainly to when that passage was made, it related mainly to the issue of dishonesty and corruption. That is my submission. But I would submit that even bad faith in that context, if one is going to find bad faith, it's going to be linked to dishonesty that the court alluded to in reference to possible fraud or corruption. I do not accept that a mere on motion proceedings, a mere finding of bad faith on affidavits without more is sufficient to prove a delictual claim.
Now, you may have difficulty accepting that, Mr. Motepe, but that's what Steenkamp says.
I hear you, my lady. I understand it differently, to say there must be an element of dishonesty established. But I've made my submission.
Yes. So if we proceed on the assumption that according to Steenkamp and Gore, fraud does not need to be established, is it necessary for us to consider whether fraud has been established in this case and whether the pleadings allege fraud?
Well, indeed, you have to, because we're not, as I've submitted at the beginning, we're not dealing with a review here, where affidavits simply pass the muster. We're dealing with trial proceedings. And the rules of pleadings dictate that we've got to see what is it that was alleged and then analyze what was proven in the affidavits. So I do not accept that in this case, there has been sufficient allegations, and additionally that there is proof in the affidavit tender. So I do not accept, if that answers your question.
If I can refer you to the written submissions prepared on behalf of your client. Paragraph 1 says that the affidavits, and I'm quoting, the affidavits intended as evidence in lieu of oral evidence do not allege any fraud or dishonesty at the time of the award of the tender. Do you stand by that submission?
Yes, I stand by that submission.
Let me just refer you to 3 extracts of the record, which may be contrary to what was submitted there. Volume 7, page 672, at paragraph 33. The replying affidavit opposed to by Mr. Rieder, which was admitted as evidence in the proceedings, where Mr. Rieder says the municipality and the joint venture at times attempted to manipulate the CIB grading of the joint venture. And paragraph 46 of the same affidavit, Mr. Motepe, at page 674, Mr. Rieder says, and I quote, "It is quite clear that the first respondent deliberately failed to consider the percentage of contract value that the fourth respondent would manage or exercise, being only 30% of the contract value. The final reference I'd like to refer you to is paragraph 24B of the same affidavit at page 668, where Mr. Rieder says, and I quote, "The awarding of locality points to the joint venture in this regard is nothing more than a sham." So I repeat my first question. Do you still stand by the submission in paragraph 1 of the written submissions that the affidavits do not allege dishonesty?
Justice, if one looks at what we say in our heads, we specifically refer to the funding papers, inclusive of supplementary papers. That when that decision was attacked in the funding papers, there was no mention of fraud or corruption. The collusion that comes in the supplementary.
Please refer me to the written submissions where that is limited to what is said in the founding papers. In paragraph 1.
In paragraph 18, we deal with that at paragraph 16.
Mr. Motepe, I would like us to deal with the submissions in paragraph 1, please, if we may.
My lady, paragraph 1, it starts with "in our law," and I'm not sure if we're talking about the same paragraph. Paragraph 1 of our submissions. It starts with "in our law, fraud is not easily inferred." So I'm not sure if we're dealing with the same.
Now, I'm looking at line 4. That's the sentence that I read earlier, Mr. Motepe. And that's the sentence that I'm asking you with the respondent stands by that, to say that the affidavits tendered in evidence did not allege any dishonesty. Or would you like to qualify that submission at this stage?
Perhaps it is best qualified to say in its funding papers, it did not allege any fraud or dishonesty. But Justice, my answer does not end there. And I've already submitted that this being, it's not motion proceedings, we're dealing with a trial here. And that's why I was trying to go back to what is it that was alleged by the applicant. And ultimately, one must assess whatever is proven against the allegations made by the applicant in its particulars of claim. And one will see that the fraud relates only to the joint venture, but dishonesty is reference only to the fact that when the second award was made, the municipality ignored the allegations that were made by Esorfranki in the earlier application of impropriety. But what that ignores is that those were still allegations yet untested in a court of law. They were still untested. The first award was set aside purely because municipality relied on regulations that were set aside. And therefore, one cannot accuse municipality that when it awarded the second tender, and we must bear in mind that the first tender is set aside on 27 January. On 1 February, already there's an evaluation of the tender. On 9 February, there is an award. The issue being, at the time when the municipality awarded the second tender, one cannot say it was dishonest because it ignored what Esorfranki said in his funding papers are taking the first award, because the first was settled purely on the basis of the regulations having been set aside. And it was not on the factual allegations made by Esorfranki. So there was not yet a finding of facts. And in fact, it is a pity that the affidavit of the municipality was not placed before the trial court. And that I accept it's a disadvantage. But one must bear in mind that when the municipality filed its plea, it said the following, and I can refer your justices to paragraph 3 and paragraph 2. It said, while Justice Matojane found, for example, that joint venture did not have grade 9 CE by CIDB, the forensic auditors have found that it in fact had that grading. Now, I know that the affidavit of the municipality was not placed before court, but the point I make is, before one goes on a quantum leap to say the mere reason that when we consider the second tender, we ignored the allegations, and these were mere allegations by Esorfranki. One must bear in mind what the municipality had alleged and what it intended to tender as evidence. Evidence from a forensic auditor who said, from what is quoted, who specifically says, it does appear that the joint venture in fact did have 9 CE grading. Now, while I accept the findings of Matojaneji, that on motion, that's what he found, that there was no 9 CE grading. The point is, and as Justice Nicholas correctly said in the SCA.
Mr. Motepe, sorry, the Ernst & Young report, was that admitted as evidence?
Well, it was not let me explain why.
Just if it was not admitted as evidence, can you rely on it in this court, Mr. Motepe?
No, I'm not relying on it to establish the fact that there was 9 CE grading. That's not the purpose of this. The point I'm making is it is insufficient for one simply to rely on the affidavits when even in the pleadings there was a suggestion that there might have been 9 CE grading. And again, it's just to show the whether there was intentional wrongdoing by the municipality, because if they were misled into believing that there was 9 CE grading, you cannot then jump to conclusion that they were dishonest in their assessment. And I accept. And Ernst & Young was not, the evidence was not led, but here's the reason why. And it appears from the address of Mr. Luderitz and Mr. Mukari. Mr. Mukari says...
I'm very sorry, my sister. Mr. Motepe, we have very limited time. I don't know what point it serves to try to explain why this was never led. If it was never led, it's not evidence. Do you want to just respond to my sister's question directly, please, and let my sister move on to the next question? I think we're wasting time.
I accept it was not evidence, it was not, but the point that I make, for you to then make a conclusion of dishonesty against the municipality, it is Esorfranki that ought to have alleged that even on the facts that it had, there was something more. In other words, it's not simply that it made allegations in the funding affidavit, in the initial attack, and those allegations were ignored when the tender was awarded for the second time. That is not sufficient. That is the point that I'm making.
Is it not more the municipality that should have presented evidence along the lines of what that report says, or presented that evidence and have it admitted the same way as the affidavits were admitted, for you then to be able to make the submissions that you are making before us? Otherwise, I just do not see how those submissions can be made.
Justice, my submission is
my sister, I'm not interrupt. Yeah.
Justice, my submission is that the one who alleges fraud must prove it. The one who alleges fraud must prove it. And it is not, while I accept that we did not file
Right, I'll stop. Maybe I'm ending up being the one who's wasting time then. Please continue responding to my sister's question. I'll leave the point I was making. I'll leave it be.
Well, I believe I had answered the question, unless if Justice Taron has got a follow-up question.
Thank you. You have, Mr. Motepe.
Yes, but then I want to, and just to emphasize.
Mr. Motepe.
Yes, madam.
Earlier, you referred, Justice Taron, to the particulars of claim.
Yes, madam.
You said that the fraud that was alleged, it was the fraud by the joint venture and not the municipality.
That is correct.
I'd like to take you to page 17 of the particulars of claim, paragraph 25, where the fraud is alleged as being the fraud by the municipality. If you read paragraph 25, you will see that paragraph 25 says that the award of the tender to the joint venture was as a result of bias by the first defendant, that is now municipality, in favor of the joint venture, and deliberate dishonesty and of fraud and corruption on the part of the first, second, and third defendants. So it is not correct to say that in the particulars of claim there was no fraud alleged against the municipality. Now, paragraph 25 is general. It deals with both the first and the second award. But if you look at paragraph 26.5, it then deals with the second award. Just needed to correct that.
Yes, but let me explain my submission. Paragraph 25, it's a mere summation, or if I may say so, a summary of what has already been alleged in paragraph 13. Paragraph 13 has distinctly identified what fraud are we talking about. So paragraph 25 is more of a summarizing of what has been said. And if one goes to paragraph 26.
But does it allege fraud by the municipality?
The point I make, not distinctly. There's no allegation saying municipality committed fraud by doing this and that. Whereas with the joint venture, there is a specific allegation that you committed fraud by alleging locality when you were not from the local area, that you allege that the Chinese national was in fact naturalized South African when it was not. Is it accurate
to say? Is it accurate to make a submission that there was no fraud alleged against the municipality?
The submission, and we take that first sentence of our heads, we refer to authority, we say you must allege fraud distinctly and prove it distinctly. You don't simply make an allegation. You say there was fraud committed by doing the following. And that we see. The appellant is quite aware. The applicant is quite aware. That is why when it deals with the joint venture, it specifically tells the one who is the pleading what conduct is being alleged to have been fraudulent. We don't find that with relation to the municipality. What we in fact find in paragraph 26.7, it is then when it deals with the second award, that why does it say municipality committed the wrong? And the conclusion is at paragraph 26.7.7.1. And in that paragraph, again, there is no, so it says, you are aware of the following facts. It lists them in 26.7.1 up to 26.7.7. And then it concludes at 26.7.7.1 that because of this, you intentionally, deliberately, dishonestly, and by virtue of its dishonest conduct, awarded the tender to the joint venture. So there it alleges dishonesty, but there's no allegation of fraud in that. So the point I'm making, when one, as we see in the heads of arguments, once they say there was fraud committed by municipality, we've got to see it not simply in the affidavits, it's got to start firstly in the pleadings. We've got to see what was alleged. Otherwise, how is the municipality expected to come to court and present its evidence? What allegation? What evidence must it prepare? And in fact, that's what municipality raised in its plea, to say, but which officials, what conduct? There was no answer to it. So, but that is our first submission. But let's then look at what the SCA finds, because there is, with respect, there seems to be suggestion that the SCA found that the municipality was somehow corrupt or well, let's say committed fraud. And I'm referring to the argument raised by my learned friends. Even in their heads, they do not distinguish the conduct that happened during the award of the tender, whether the first or the second, and the conduct that happened during litigation. And we say the two must not be conflated. What happened during litigation and what has been referred to as collusion is got nothing to do with the award of the tender, be it the first or the second. Nothing to do with that. Those are two distinct allegations that must be made and proven. But I want to refer this court to paragraph 10 of the SCA judgment. And I'm talking about the review judgment at page 265. It summarizes, it says the High Court found that the tender submitted by the joint venture did not comply with the bid specifications, that it was guilty of fronting, and that is one of the allegations of corruption, and that the municipality's decision was motivated by bias and bad faith. So there's an end there. It doesn't say that municipality was a participant in this fraud or dishonesty. It simply, when it awarded the tender, awarded that on motivated by bias and bad faith, and which I say, these are ordinary terms of findings that we find under Section 6 of budget, but they do not, without more, establish liability when one deals with dealing. But I want to proceed further. In the same SCA judgment, and I know that my friends also referred to paragraph 22, where in the second line, the SCA says, first, the parties to that contract acted dishonestly and unscrupulously, and the joint venture was not qualified to execute the contract. But if one considers what the SC had said earlier on, what it was referring to, indeed, there were two parties to the contract that were proven to have been fraudulent and corrupt, and those were two joint venture entities. But it is not here referring to the municipality. If there's any doubt, paragraph 32 puts it beyond doubt. In the second sentence, it says, instead of complying with his duty to act in the public interest and to allow the serious allegations of fraud and dishonesty in the tender process to be ventilated and decided in the legal proceedings, it chose to identify itself with the interests of the tenderers who stood accused of improper conduct. In other words, it says it is the joint venture that conducted itself fraudulently and dishonestly. It is accusing the municipality of, instead of then investigating, it identified itself, but not that it is the municipality that perpetrated this fraud and dishonesty. And we submit that if one considers the pleadings, one considers the evidence, and one considers the findings of both Matojani J and the SCA in the review proceedings, there's no room to find that municipality was found to have been fraudulent or dishonest. The allegations being made, those of dishonesty and collusion, as I've indicated, and the facts here are very important, and one must have regard to the judgment of Matojani J, also that of the SCA, but Matojani J, and this is important, at paragraph 8, this is page 55 and 56. Let's start at paragraph 7, same page 55. And one must bear this in mind. And I'm addressing now the allegations of collusion. And again, the distinction must be drawn. This is now collusion during the interim interdict stage, where we're accused of having appealed findings that were unappealable because they were interim in nature. That is the conduct that, and my friend simply conflates the two, but one should not do that. But to understand why municipality did appeal the interim interdict of Fabricius J, and why it proceeded in attempting to have the works executed, one must refer to paragraph 7 and 8. Municipality was faced with a local state of disaster that had been declared. The community was in need of water. It was supplying the community with water tanks, and it was saying that this is not adequate. We need to move with speed to execute the works. And when there was an interim interdict by Justice Fabricius, one must bear in mind what Matojani said in paragraph 23. It says Justice Fabricius granted that interim interdict without considering the municipality's affidavit. And again, I accept it is not before court, but it was ultimately assessed by the SCA when well, by Matojani J ultimately when he dealt with the review application, by the SCA when he dealt with the appeal. But the point is, municipality was perfectly entitled, and this is the finding of Matojani J. It was perfectly entitled then, where it believed that it had acted properly in awarding the tender, and where it believed that it has filed an affidavit trying to explain to the court why an interim interdict should not be granted. We are facing a state of disaster, people do not have water, and it believed that it had a good case resisting the review. When Justice Fabricius did not consider its affidavit, municipality, as Matojani J correctly finds, it then filed an application for leave to appeal. The fact that it was an interim interdict is one of the factors considered, but we know that the main issue is whether it was in the interest of justice that an appeal be had. Now, if you are faced with a state of disaster, you try to put your case to say on the balance of convenience, don't grant an interim interdict, and that the court does not take into account. What is so wrong with the municipality then attempting to appeal? So the issue of collusion with respect and being used now to conflate the two, that it shows that municipality served to push the interest of the joint venture with respect is misplaced. What municipality would have been concerned with was the plight of the poor, those without water. And
Mr. Mutepi, I'm sorry to interrupt you, but I'm not clear why reliance on the findings that were made by the High Court and the SCA in respect of the review proceedings is determinative of the case, because to the extent that the municipality was facing a private law claim in delict, you've analyzed the pleadings and you have told us why you say that fraud wasn't alleged. But putting that issue aside for a moment, isn't the key point, what was the evidence that served before the trial court in the delictual claim? If that evidence supported dishonesty or bias or any one of the grounds that Steenkamp permits a delictual case to be brought on, isn't that the true inquiry?
It is, but we align ourselves with the findings of Nichols J, where she says that evidence, even the evidence in affidavit, was not sufficient because here there would have been dispute of facts and people have to give oral evidence and then cross-examine.
But is that proposition, I'm sorry to interrupt, but we mustn't confuse trial proceedings with motion proceedings.
Yes.
The affidavits were allowed in for the truth of their contents, and no cross-examination took place and no evidence was provided by the municipality to contradict the evidence that was placed before the trial court. So the question is whether that evidence was sufficient to make out one or other of the grounds that would found a delictual claim. And among the evidence that was put up was to say that there was an intentional manipulation by the municipality of the scoring so as to advantage the joint venture, knowing that by so doing it would win the tender. Let's not quibble about fraud. Let's just ask, isn't that a dishonest manipulation of the processes of law by which lawful tenders are granted? And isn't that sufficient?
Yes, Justice, like I said at the beginning, I'm at a disadvantage because municipality's affidavit was not placed before court. But yes. On the facts that I cannot argue outside of the facts
so if Steenkamp is not is the law as it is, then would you accept that that there was an evidential foundation for a delictual claim, whether sufficient for fraud, but at least sufficient to show a form of dishonesty or rank illegality in the administration of the tender, and that would found a delictual claim?
Yes, I accept that it was found that there was bad faith and perhaps to an extent dishonesty by the municipality.
Thank you.
I accept that.
Thank you.
Yes, but I was dealing with the allegations, and that was the first argument that we intended to advance. And again, I accept that we did not place any affidavit of our own, which is a disadvantage. But that was only the first argument. Now coming to causation, and starting with factual causation, the important point is this: CCT, and that is clear even from Matojani J. CCT was one of the bidders that has submitted the bid. In its pleadings, it contended that it ought to have been awarded the bid, and in fact, it sought an order that it be awarded that bid. And that suggests, and it destroys any suggestion that absent any illegal conduct, whichever way one characterizes that conduct, whether it's fraudulent or absent that, because that is Esorfranki's argument, that absent that, it would have won. But that doesn't follow. In addition to many questions that have been posed to my learned friend, but one of the most important is exactly that CCT came before court. It attacked the proceedings, the award of the tender, and said we should be awarded the tender. Now, there is a possibility that it could have been awarded the tender, and we don't know on what basis it was saying that it ought to have been awarded the tender. It may be that municipality treated it unfairly. We don't know. We don't have those facts. I accept that. But that is sufficient to dispel any myth that it was a foregone conclusion. Cases like Trancon, under just an equitable remedy, went on to award because it was a foregone conclusion in those cases. Not so in this case. And Esorfranki cannot approbate and reprobate. If it says municipality conducted its proceedings wrongly and its reports were flawed, it cannot again refer on the same reports to say that it is the party that ought to have succeeded. Those reports, if they are flawed, they may have been flawed in such a way that deserving participant had been disqualified. We don't know that. So it is not only speculative, but it is wrong to suggest that on the facts of this case, it was a foregone conclusion that it would have been awarded the tender. Just purely on the CCT having submitted the tender, and that is not in dispute. Yes, ultimately, and this is one of the findings of Judge Matojani, that it seems that there were some discussions between the two, and ultimately CCT withdrew its prayer that it be awarded the tender. But that is neither here nor there. The issue is it believed when it launched the proceeding, when it launched its application, that it was entitled to the award of the tender. So that destroy the applicant's case insofar as factual causation is concerned.
I don't know if my brother Justice Unterholter is done.
Yes, I am.
Thank you. I just want to test that submission, Mr. Mutipe. The applicant is specific on why it believes that it ought to have been awarded the contract. Lowest on price, therefore 90 points. And then after it all, it also then says it scored the highest. And therefore, unless there were objective criteria or justifiable reasons for not awarding it the contract, it ought to have been awarded the contract. We can, I believe, and you'll correct me if I'm wrong, we can only place reliance on what CCT alleged if we put on the table what it is exactly that CCT alleged, to then conclude that it is it that ought to have been awarded the contract. We cannot reach the conclusion that you want us to reach purely on the basis that CCT alleged that it ought to have been awarded the contract, because we have specifics with regard to the applicant. Let us have specifics with regard to CCT as well, and see whether objectively those CCT specifics can cut across those of the applicant.
Justice Madlanga, if that proposition is correct, then Esorfranki would have won the tender by Water Affairs and Appellant. It would not have been won by Varanani, because it still comes to court and it is clear that its price was lower than that of Varanani. But unfortunately, we don't know.
Let's just deal with your point with regard to CCT, please. And then you can make your point about Varanani.
But I may be seen to be speculating as to what may not have happened. There are no facts to prove that CCT would have been appointed, and that is not my submission. But I'm saying there is no proof that Esorfranki would have been appointed simply because it has the lowest price and so forth. And I'm making an example that, and it does happen in tenders, that a tender that has tendered low does not win the tender. And I'm giving an example that it has happened.
It's just not low in terms of price only. Low in terms of price, but highest in terms of scoring. At least that is what it alleges. So
yes,
please look at those together.
Yes, but the decision maker is not bound to award the tender to that tender. It can award a tender to somebody else who did not even achieve the same scoring as that of Esorfranki. For example, in one of the I believe it's in the first bid, there was, for example, Basel Reid there, one of the entities, and one is known as a well-established entity in construction industry. And if municipality for some reason believe we trust these guys, their track record and so forth, so we look at that track record. What did they do when they executed one of the tenders, perhaps in KZN or wherever? And then we take that factor, we say we cannot risk. We're dealing with a local state of disaster. We need this water agency. Let's not take a risk with somebody who's untried. So the municipality, as an objective factor, they may quite correctly then decide that we go with that bidder. So it is not given that it is Esorfranki that was going to win. That's my submission.
I would have appreciated these submissions more if, in terms of what is set out in section 2(1)A up to F, if you were able to slot in your submissions within one of those paragraphs under section 2(1) of the PPPFA. Now, making these submissions and just saying, because we all know, and I'm sure you also accept, that the municipality cannot award to any of the tenderers at whim. And I'm not saying that that is what you are suggesting, but I'm mentioning that purely to make the point that I would understand your submissions better if you're saying, for example, in terms of section 2(1)F, 2(1)G, or whatever, this is what the municipality could have done. I would appreciate your submissions better.
Yes, but on that subsection 2(1)F, if I'm not mistaken, it is the one that says, unless on some objective ground, municipality decides to award to somebody. In other words, you award to the bidder who scores the highest, unless there's some objective grounds that then warrants the award to somebody else. And that's my submission. And again,
the municipality not bear an evidentiary burden. I won't say owners, because the owners would have been on the applicant. at the very least, an evidentiary, what they call the weerleggingslast in Afrikaans. Would it not have had that if it wanted to rely on the sort of things you are relying on now?
Justice Madlanga, again, it takes me to the affidavit that we did not file, and I cannot go there. I don't have those facts, unfortunately. All that I can submit is a submission that I've made that it is not given that municipality was then bound to award the tender to Esorfranki. But as to what were the factors relevant at the time, unfortunately, I'm unable to make that submission because I don't have those facts before.
All right, let's leave it there, Mr. Mutipe. Thank you very much. Please continue.
Yes. So those are my submissions on the factual causation.
Mr. Mutepe, may I just ask you, in this matter, we know that there was an order by Prela J. That order was made by consent, not so.
It is so. It is so.
So it means that the municipality accepted that as ordered by Prela J, it had to re-advertise the tender in compliance with the Preferential Procurement Framework Act.
Perhaps evaluate Justice.
Evaluate, that's correct. But at that time, the municipality had certain information by the time it did this re-evaluation, not so. For example, it knew that the joint venture CIDB grading was inadequate, not so.
Again, I would not accept that.
Why not?
I would not accept that it knew. And I've made this submission before, that what was before Prela and the concession.
Prela J, not Prela. Prela J.
My apologies. What was before Justice Prela and the concession was based on the regulations having been set aside in 2010. Municipality was unaware when it awarded the first tender that the regulations had been set aside. So it considered based on that legal point. But it is incorrect to say it already knew that there were these facts as though they had been established. There were allegations which were yet untested. And
okay, now complete your sentence. I want to follow on that.
And with the chronology, I again need to emphasize this. Prela J's order is 27 January 2011. Because of the agency attended in making sure that the people of Gianni have good water, the parties agreed to an expedited evaluation. So from 27 January, 1 February evaluation committee already evaluates the tender. 9 February, the BAC makes its award. So it is not as though municipality had months on end to then take each and every allegations by Esorfranki, to send someone with a car to go, for example, and investigate what is alleged about the locality. It's not that municipality had that time. I just wanted to make that point that has to be taken into account. Firstly, it was mere allegations not yet proven, one. But secondly, the time period from 27 January, it's a matter of 3-4 days. Already it had made an evaluation. But I was just answering that it is not correct.
Yes, no, I hear you. Yes. But I want you to go to the record, please, and that is in both these documents is in volume 5. This concerns the adjudication report. What is contained in the adjudication report and what is contained in the re-adjudication report. Now, the re-adjudication report followed upon the Prela J consent order. Am I correct?
Yes, correct.
So let's look at page, first, we will look at page 468, which is the original adjudication report. At page 468, regrettably, it's not very legible, but somebody has in manuscript indicated for us what is written there. And I just want to check that you accept that the figure there is in respect of the joint venture A and B. The figure there is 8 capital CE. That's for the joint venture. That's a CIDB contractor's rating. Do you accept that?
If it is indeed what is put in manuscript, then I accept. But I also cannot see what is that.
Well, I don't know. I'm going on what is written there, and I have no reason to disbelieve it. But do you accept that is a HCE is correct there? It does look like HCE, but my eyes are failing.
Perhaps for the purpose of the question that needs to be posed, but I cannot accept if I don't see exactly what it says. But
yes,
for the purpose of this question, we shall assume.
For purposes of the question, let's proceed then. Compare that HCE to 439, please. This is the re-adjudication report. Page 439. This is fortunately far more legible. Even I can read it.
Yes.
So the joint venture there scores 9 CE.
Yes.
How did that happen?
Well, in the papers, it is dealt with, and the accusation is that so there was a grading that did exist, 9 CE, but the allegation is that the allegation and the finding is that grading was produced by the municipality a year after the award. That is the allegation. That is the finding by Matojani J.
Has that allegation ever been counted on the papers? Because, as you correctly say, the allegation is made numerous times in the papers. And we know now that the affidavit stands as evidence and that these deponents were, despite being offered the opportunity, they were not cross-examined. So this evidence stands. Has that evidence ever been counted? That because the allegation is that this was sheer manipulation. This was deliberate dishonesty on the part of the municipality in manipulating the CIDB grading. Has it ever been counted? And if so, can you show me where in the papers, please?
No, I'm going to address that, but in reference to what Matojani J has found, and I'm going to refer to paragraph 70.
70?
Page 87, yes, 70.
Page 87, yes.
Yeah. The findings, I don't think this is the correct paragraph I wanted to refer to, but let me make this submission. I'll point your lordship to the correct paragraphs. The point is this: a 9 CE grading certificate was produced. Esorfranki's attack is that, but this is dated a year later. That was the allegation, and that was the finding by Matojani J. But the argument I want to advance is this: assuming that it is so, that there was this 9 CE grading certificate before the evaluators or the adjudicators, but the court ultimately found that, in fact, that CIDB certificate should not have been considered. Does it make the BEC or the BAC members dishonest if they were faced with that 9 CE certificate? That's the issue. So the fact is, what did they have before them? If they only had 8 CE, but they put 9 CE, then perhaps one is very close to proving dishonesty. But here we are told, when we read the judgment, is that and the attack by Esorfranki is that what was produced while it was 9 CE, in fact it was dated much later. But I must add, it is just so unfair that I sit here knowing what the correct facts are, but I cannot deal with them, and I accept.
Well, that's the case. That's the case you land with. You see, Mr. Motepe, pleadings are there for a reason.
No,
and in this
I
case,
understand.
the affidavits are. Can I just finish? The affidavits are the pleadings. So you've made your bed. When I say you, I mean the municipality. It's made its bed, it must lay on it.
Yes.
So you must take me to the, because I'm very interested in seeing where the passages in the judgment that you say deals with this aspect. But if you have nothing further on this point, can I raise another point in the record?
Can I just refer to paragraph 71? It is paragraph 71.
71, okay. What page is that?
It's page 87.
87, yes. Yes, sir.
It says, in the bid evaluation report of 1 February 2011, the municipality evaluated the joint venture lying on a screen down, dated 27 October 2011, approximately a year after the date of the bid submission. So the point I make is this, that the grading was there, but the issue was that, but that grading should not have been taken account because it was made a year later. Now the question is going to follow, if the grading certificate was produced on 1 February 2011, how does it happen that it is dated 27 October 2011? How does it happen? Because the logic dictates that if the decision is taken 1 February 2011, the certificate must have been produced prior. But if one then wants to understand this, and I'm talking only of understanding the finding by Matojani J, if one, just for the purpose of understanding this, and I would suggest that this court has a look at the affidavits served before Matojani J, that led Matojani J to make this finding. And one finds that CIDB certificate. If I'm permitted, I can point out exactly where it is. But the point I made is that whereas the initial report says the joint venture had 8 CE grading, the subsequent report says it had 9 CE grading. And on what has been found, there was indeed that 9 CE grading. So the question was, but when was it issued and so forth? That was a dispute. But the poor BEC evaluators faced with this, and no doubt mountains of documents and various bidders, they are faced with this and they see the 9 CE grading certificate, they make an evaluation based on it. Now, are they dishonest simply because the initial report said they had 8 CE?
Well, it does raise questions, Mr. Motepe. I'd like to move on. I get the point that you're making. It goes further than that. Can we go to the record then, page 470? Again, this is a document which regrettably is of poor legibility, but it's more legible than the other one. Can you see at the top that Klong Yang Trading? There is marked, this is in respect of previously disadvantaged individuals. There's a rating of 1.5. Do you accept that it's correct?
Yes, it looks like 1.5, yes.
Okay, now that's the original adjudication report. It was prepared by consultants for the Mopani municipality. Then we go back to 440. Here's the re-adjudication report of 1 February 2011. There, Klongre Young Trading now has a PTY of 3. And we see the price has been corrected. Price 85.3, Esorfranki 90. And there's a PTY of 3. How did this increase happen in the re-adjudication?
No, that unfortunately I can't answer without giving evidence from the bar.
Yes, well, we don't want that. We don't want that. Can you explain to me the discrepancy in this PDI points inscription from the re-adjudication to the original re-adjudication?
No, Justice, as I say, to do that, I'll be giving evidence from the bar. I don't have those facts before me. The court doesn't have them. So,
you know, I understand your conundrum. But tell me, Mr. Motepe, what is the court to do? The court must, as my brother, I think it was Unterhalter, AJ said earlier, we must have a look at the affidavits. We are not bound by findings of either the majority or the minority. We must look objectively at the affidavits, unanswered as they are, and see whether on these affidavits, on the objective facts, with the annexures, like these reports, for example, whether there's a suggestion of dishonesty. I put it no higher than that. Let's forget about fraud, dishonesty. Are you saying these are bona fide mistakes, where suddenly the mistakes in favor of a particular tenderer and against another tenderer? Or would we be entitled to say that this is suggestive of deliberate dishonesty to favor one tenderer over another by the municipality and its officials?
Before you respond, Mr. Mutipe, the hour is up. How much more time do you want?
It depends on the questions being posed, but I was going to then conclude on the legal causation and of course the public policy. But basically those are very short.
Yeah,
that is 5 to 10 minutes. No more than
5 to 10 minutes.
Excluding the questions as I've indicated.
Thank you. Please proceed, Mr. Mutipe.
Yes. And now I'm forgetting. Justice Majid, could you please remind me?
No, it was a long-winded question. I'll cut it short. These are, I've pointed out two mistakes,
yes.
or two discrepancies. Are they bona fide mistakes, or are we entitled, absent any answer to the affidavits, allegations in the affidavits, are we entitled to infer that these acts of deliberate dishonesty to favor this particular tender over another?
I'm going to answer it as follows. If one looks at the judgments of Matujani J and of the SCA.
I'm so sorry. I hate interrupting counsel because I endured many times during my career. But forget about the judgments.
Yes, I want to forget. I want to forget about them, but I'm making a different point.
Okay.
If one has to look at them, and that this court, and I would strongly urge this court, that simply to understand how the findings were made in those courts, this court must have regard to the affidavit filed by the municipality at volume 10. For example, to understand why this 9CE grading came about. And when one looks at that, one will see all these questions, and one can then make a fair evaluation, because this is an apex court. It is being asked to give a very far-reaching remedy. And I would suggest, even with the disadvantage of the affidavits not having been placed before the trial court, but because we're relying so much in the SCA judgment and the Matujani J judgment, I would urge this court to look at the affidavit of the municipality, at least to interpret those judgments. And then this court will make its own evaluation. Was there, in fact, deliberate manipulation? Because it's a serious matter to make that finding that there was a deliberate manipulation, only to find that it is only because the affidavits were not placed before the trial court, but they do exist. They were evaluated by the courts. Both the High Court and the SCA evaluated those affidavits. I can see no bar, and I know my friend will probably object that you shouldn't. I can see no bar why, in understanding those two judgments, this court should not have regard to the affidavit by the municipality.
Well, I was going to ask you, Mr. Motepe, you didn't do the, not you, but counsel for Mopani Municipality didn't do the same as Mr. Luderitz did for Esorfranki in the trial before Makoka J. One may have expected, since you rely so heavily on this answering affidavit in those proceedings, one may have expected him to say, well, we are not going to lead to cross-examine, nor we are going to adduce any oral evidence. We are simply going to place this affidavit also before the court on the same basis and ask that this evidence be considered for the as answer in this claim for dealing, for damages in dealing.
No, I accept that was not done. That was not done, and that is what I've been at pains to explain, that it would have made my argument much easier. But we've got to recall what my predecessor was faced with. The pleadings, as I've analyzed them, and in my submission, not distinctly alleging a fraud. And yes, I understand the issue about dishonesty. He was faced with that. When he gets to court, even though allegations are now made general, and when I say general, I refer to paragraph 25, 26, they are made general, not distinctly as to what is fraudulent. But when he gets to court, there is an undertaking that, look, yes, those two courts did not find fraud, and this court did not go that far, That is the concession made, and correctly so by Mr. Lutheritz. At page 2103, says, but my lord, we say that on the law, it is not necessary, my lord, to go that far. In other ways, dealing with the issue of fraud. Mr. Mokari then, thereafter, he says that, look, now that this concession has been made, in fact, we had and I'm referring now to page 2118. He says we intended leading a witness from the forensic auditors. This is the forensic auditors appointed by Lepele and Department of Water Affairs after the tender was set aside. He says both ourselves and the plaintiff subpoenaed this witness. And this witness was going to show that, in fact, there is no fraud on the side of the municipality. But because this has been considered that it is no longer an issue, I'm no longer proceeding to call that witness. And perhaps those conditions, and it is common cause that witness was not called. But if one considers what Mr. Mokari says the witness was going to say, I know that is not necessarily sufficient. But at page 21220, he says, so the witness from Ernst & Young was coming to specifically testify about whether he found any fraud on the part of the municipality that he did not. That's what he was coming to say. And in paragraph page 2118, lines 17 to 2024, that's where he says, in fact, this witness was subpoenaed by both of us, meaning Esorfranki and Mopani. And unfortunately, as it happens, and based on that concession, he took a view that it is not necessary then to proceed with this evidence because the affidavits already before court and the pleadings do not prove a fraud or dishonesty.
Mr. Motepe, I'm sorry again, but this is the point that my sister Tron J made with you earlier, that that sort of Steenkamp is not based on a finding of fraud only. So it seems to me that Mr. Lutheritz made quite clear, as he indicated earlier, that the case went beyond fraud. It was a case of dishonesty, ulterior purpose, etc., excluding fraud for present purposes. So it seems to me then that is what decision the municipality calculatedly took, and it is a decision that it must rest with. I have nothing further. Thank you, Justice Madlanga.
But just in conclusion,
no, you certainly may answer. I have no further questions, but you may answer. Yes.
Yes, but just in conclusion, my little friends in their heads, they persist with allegation of fraud, and just paragraph 1, it just tells you that, and they say the case is about whether a municipality should be held liable for delictual damages of an unsuccessful tenderer for the loss of profit, whether award of a tender is vitiated by the fraudulent and dishonest conduct on the part of such municipality.
Yes, the second part is what matters, and dishonest. They still rely on fraud, but I'm saying to you, when Mr. Mokari made his opening address and said, now that fraud has been abandoned in the opening address, I do not deem it necessary to call any witnesses. Well, as you've just said, fraudulent and dishonest conduct. Anyway, I have nothing further. Thank you, Mr. Motepe.
Yes, but I must just conclude that technicality must not ignore the fact that the affidavits before the High Court and the SCA were evaluated by our courts, and therefore they should serve as this court, to be fair to the parties, must not ignore that affidavit. As a court, please.
Thank you. May I, colleagues, unless it's a follow-up on this, I just wanted to manage time. Mr. Mutipe, you said you want 5 minutes to address 2 issues.
Yes.
Please address those 2 issues in 5 minutes. And
On the legal
colleagues, let us wait for him to address 5 minutes. And Mr. Mutipe, when you are done with addressing those 2 issues, and I will time you, please indicate to me that I am now done. And then colleagues, let us hold back on questions. Let him finish on those submissions. And thereafter, colleagues, you may ask as many questions as you want, and we'll know that Mr. Mutipe is done with his own submissions. So everything else that follows is just questions from colleagues, and we'll go on and on until colleagues are done. Mr. Mutipe, 5 minutes to address the 2 issues, please.
I should be less. On legal possession, our argument is very simple, and along with it goes along with the findings of Nicholas J in the SCA. Esorfranki, on its own version, it retendered, meaning after the second tender was set aside, there was a third tender. It proceeded and participated in that tender. It did not succeed in that tender. That was a lawful process. It, of course, tried to interdict that tender, but it failed, or the execution of the award, but it failed. We know the tender was awarded to Faranani. When there was a retender and it retendered, there was an intervening event that disqualified it from now seeking to sue municipality on a delictual claim. And linked to that, so we say it is novus actus, we deal with that in our heads, but just as a matter of public policy, it should not be allowed. And in a country like South Africa, rife with corruption, our municipalities will be stripped bare. The proper course of action is, of course, to proceed. I would suggest in circumstances of a case where, in adjudicating a tender, one is found to have been, one of the officials perhaps is found to have been dishonest. Perhaps the starting point is to punish the official. And we know there have been various judgments recently of pension funds of various officials being attached by the SIU and so forth. There are various judgments, and the law allows for that. So that it is not the very same poor members of the public already suffering from poor service delivery, who must now be burdened some more, because a tenderer, and it is going to open a can of worms, because one is going to see many tenderers bringing these delictual claims and making out or making allegations. And if the case presented by the municipality is not properly pleaded, or the evidence is not properly placed, then they will succeed. And that, with respect, it is something that this court must bear in mind. The likely impact, and talking about public policy. So this is not a case where the court should permit, at least on the facts of this case, even if municipality did not properly place its evidence before this court. Even with that, this is not a case where municipality should be held liable for this delictual damages. Public policy should not allow. And those basically are my submissions. And in concluding, this matter, it was more about the facts more than the law, honestly. And we submit it is not a matter that should have detained this court. It does not engage any constitutional issue. There's no important question of law being argued. So we say it should be dismissed on that grant alone. But alternatively, just on the merits, the elements of delict have not been proven, and we say that the appeal should be dismissed with cost of 2 council votes. I conclude on those words.
Thank you, Mr. Mutipe. Yes, my sister Justice Theron.
Justice Madlanga, Advocate
okay.
Justice Strawn has said, as a junior member of this bench, I can ask first. I'm joking. Advocate Mutepe, I'm just interested in your comment. Just a comment, and you don't have to be too elaborate about it. About what the SCA, that is the Hossan Betze judgment, said about your client, especially the first two sentences of paragraph 71 of its judgment. Can I read it to you, if you don't mind?
Yes, ma'am.
It says, it bears emphasis that in this instance, the decision maker acted deliberately and dishonestly, with bias in favor of the joint venture. It acted in bad faith, with an ulterior purpose, and fraudulently. I don't read further, but I just want to get your comment about what you have to say to what the SCA said here.
I submit that the answer, the correct answer, lies in what Nicholas J. says, that we should not rely on the findings in motion proceedings, but she proceeds to say, unlike in Minister of Finance versus Gold, in this case, no fraud, for example, has been established against the municipality. We disagree with what Justice Hussein and Betze say about the conduct of the municipality. So we disagree with them.
Okay, no problem. Thank you very much. Thanks, Justice Madlanga.
Thank you, Justice Madlanga. Mr. Matipe, Justice Majid referred you to page 440 and page 470 of the record in volume 5, relating to the jump in the PDI points awarded to the joint venture from 1.5 to 3. And he asked if you had an explanation for that, and you said that you had no explanation. You couldn't explain the difference in the points.
Yes.
Is the explanation not found, Mr. Matipe, in volume 7, page 678?
But that is the affidavits of Esorfranki.
Is the explanation, Mr. Matipe, not found there, where it says that the locality of the joint venture was not within the area of the respondent, and that the fifth respondent was in fact a shell, which was registered, I've just lost my place, yes, which was registered on the 13th of August 2010. And the first tender invitation was issued in August 2010. And the joint venture was allocated 1.5 locality points in the second tender on the basis that Clairong fell within the area of the municipality. And what Mr. Reader says in his affidavit is that Clairong was an empty shell which conducted no business and was registered immediately before the tender in order to bolster the BEE status of the joint venture. And that its locality should not therefore have contributed towards the points. Isn't that the explanation that we have before us for the jump in points?
But that is the issue precisely, Justice Strawn. That is an allegation before this court, and it is the only allegation that this court has without contrary affidavit from the municipality. So unfortunately, as I answered Justice Majid, yes, these are the allegations that are raised by Esorfranki, and unfortunately, these are the only allegations before this court. And I cannot refer to what municipality said, but I've got to accept what is before this court. I cannot go outside of, and I cannot give an explanation which would be tantamount to me leading evidence from the bar.
Yes, I don't mean to belabor this point, Mr. Matipe. Justice Majid asked you if there is an explanation for the increase in the allocation of the PDI points from 1.5 to 3. And you said there was no explanation.
No, no.
And I'm merely referring to an explanation that is on the papers. Whether it favors the applicant or the first respondent is neither here nor there. Mr. Justice Majid asked whether there was an explanation for the difference in points. And this is the explanation that's before the court for the difference in the points.
Yes, and the answer I was given was that from the side of the municipality, I cannot give an explanation on behalf of the municipality. The explanation that Justice Tharone has just referred to, an explanation by Esorfranki, and I accept we didn't put our version before court. So that is my answer. I don't have an explanation from the municipality on that aspect.
Yes, I have two more questions, please, Mr. Motepe. The one relates to whether Justice Nichols was correct in finding that once the original tender was set aside, the wrongful conduct perpetrated by the municipality did not attach to any tender, and therefore there can be no liability in delict. Now, if I understand the respondents and if I understand the submissions, they support that argument. Is that right?
Well, yes, in the heads, that's what we said. But in all honesty, I cannot longer make that submission. Otherwise, cases like Minister of Finance and Go, then would prove me wrong. So I cannot make that submission.
Thank you, Mr. Motepe. I think that concession is wisely made, because then it would mean that unlawful administrative action once it's set aside, can never attract delictual liability. My last question relates to the price of the first tender and the second tender. The initial tender was awarded at a sum of approximately 200 million. The second tender was for approximately 600 million. Now, it appears to follow from this vast difference in price that it could not have been the same work that was being tendered for. That the second tender was materially different from the first tender. What do you say to that?
Justice, with respect, it's just a matter of semantics. A tender is awarded to install pipelines for supply of water. A joint venture is appointed, executes those, but it is being accused of poor work, or because there was an interdict, it could not proceed. We do not know what damage was done when it left the pipes open and so forth. And that is why there was an intimation that we must look at the remedial action that needs to be done so that we correct the errors that have been done. But the substance of the tender doesn't change. It is to lay pipes for the supply of water for the Guyana community. The fact that in the second tender, there may have to be remedial action brought about by interdict, or brought about by the delay in executing this tender, it doesn't make it a different tender, legally speaking.
The remedial work that had to be done cost twice as much as the initial work. Didn't that then form the bulk of the second tender?
The initial tender, of course, it did form the bulk, but I cannot say 100 million was for this, 2 million was for this. I cannot say that. But what I can say is that ultimately that tender was for the same work that had to be done in the initial tender. Except in this case, there may have been remedial. I don't know if the pipes had to be removed and relayed afresh. I don't know. But it was not.
Wasn't the allegation that the work that had been done was so poorly done that the pipes had to be re-examined and looked at again? And that, in fact, was more work than merely laying the pipes. So can we say that it was the same tender as before? Can we say that the applicant was afforded the opportunity to tender for the same bid?
Justice, what I mean is that we're not now dealing with a new tender for a construction of a building or laying of pipes in a different site. It is in the exact side after declaration of state of emergency, in the same side. In fact, I would submit that the mere fact that there was more work to be done, it meant more profit for whoever would have won. But in essence, it is about the same thing. That's my submission.
The argument put forward by the municipality is that because the applicant had an opportunity to tender for the second bid, it should be non-suited.
Yes.
But does that argument hold water if the second bid was not the same as the first? The second tender was not the same as the first tender, which would mean the applicant then tendered for something that was materially different.
But Justice, again, I say it's semantics, but if one looks at it objectively, in fact, it would have been placed in even a better position had it won the tender. Because then it had more work to do.
Yes, it's not answering my question, Mr. Matipe, but I think I accept you can take it no further. Thank you very much, Mr. Justice Madlanga. Thank you, Mr. Matipe.
It looks like there are no further questions from colleagues. Thank you very much, Mr. Matipe. Yes, Mr. Luderitz, your 15 minutes, please.
Thank you, Justice Madlanga. May I perhaps offer some references that might be helpful just from a factual perspective. First of all, insofar as the submission was made that the issue of non-eligibility of the joint venture was not pertinently raised in the proceedings before Justice Prella. Of course, our learned friend is correct that award was set aside by agreement, but that with respect misses the point. The point is that the issue of non-eligibility of the joint venture was raised in the founding affidavit in the proceedings before Justice Prella. And when the municipality re-adjudicated the tender, it did so in the knowledge, having been forewarned of that fact, that the joint venture did not qualify. I'm merely going to give you the references to the relevant passages containing the undisputed evidence. This is in volume 4, page 340, paragraph 9.1, page 343, paragraph 11.1, and page 392, paragraph 8.5. If I may then deal with the undisputed evidence that absent the unlawful award of the tender to the joint venture, Esorfranki would have been the successful tenderer. I can offer the following references to the court. Page 343, paragraph 11.1. Page 352, paragraphs 14.8 and 14.9. Paragraph 14.11 on page 353, in fact, dealing specifically with section 2 of the PPPFA Act and its application, drawing the conclusions in paragraphs 14.11.1.4 in 3.5.4 that applying the objective criteria, Esorfranki would have been the successful bidder, and also paragraph 14.14 on the same page. Then in paragraph 15.5 on page 365, again, the undisputed evidence that it would have been awarded the tender. And lastly, paragraph 16.4 on page 368. So on the evidence with respect, the undisputed version before the court is that Esorfranki would have been awarded the tender absent the deliberately dishonest conduct.
Mr. Luderitz, can I just, while you're on that score, confirm with you that if you look at volume 5, page 441, This is the re-adjudication post the Prala J consent order. That the JV was, we see that 12 recommendation, the JV was awarded the tender on the basis that they scored the highest points as per the preferential point system. Is that so?
That is correct, Justice.
Okay. Yes, thank you. Sorry for the interruption. Thank you.
No, thank you. Just perhaps touching on what you've raised with me, Justice Majid, the undisputed evidence about the score tampering. Justice Tron has identified certain page references. If we can assist with a number of other references showing the undisputed evidence, in volume 7 at page 670, paragraph 27 up to paragraph 33. Then at page 678, paragraph 57, 58, 59, and then follows a number of paragraphs also identified by Justice Tron, but in particular subparagraphs A, B, and D, where the undisputed evidence of tampering is recorded in the affidavits. Then if I may briefly deal with the concept of fraud. We've already addressed the submission again made by our learned friend in his oral address that the appellant had abandoned fraud. And we showed with reference to the opening address that there was no such abandonment. There was an express reliance on the case as pleaded in the pleadings. And in fact, paragraph 25, relying specifically on fraud, was drawn to the attention of the presiding judge. The only concession that was made, we submit with respect correctly, is that no finding of fraud was made by the Supreme Court of Appeal. Our learned friend is not correct that the reliance on fraud is confined to what is alleged in paragraph 25 on page 17 of the particulars of claim. In paragraph 26, it is pleaded that the aforesaid bias, deliberate dishonesty, fraud, corruption, fraudulent misrepresentation, and collusion, collectively referred to as dishonest conduct, is based on the following facts and inter alia, and then is pleaded repeatedly the acts of deliberate dishonesty on the part of the municipality in paragraphs 26.1 all the way to paragraph 26.8, and then also in paragraph 26.17, the last line on the page, the intentional and deliberate dishonesty, the allegations of collusion specifically pleaded in paragraph 26.18. What appears from the address of our learned friend to this court is that the notion of fraud appears to have different meanings to different people. Fraud, we understand in this context, seeks to convey deliberate dishonest conduct. His Lordship Justice Goosen, as we've already pointed out, in paragraph 66 on page 2335 in volume 23, described the conduct of the municipality amounting to deliberate and intentional conduct to subvert the prescripts of section 217 of the Constitution as something in fraudem legis amounting to fraud. We have offered in our heads of argument two authorities that support the proposition that collusion is tantamount to fraud. We would submit that acts of deliberate bias would equally fall within the broad description of fraud, but ultimately our submission is that it matters not what precise tag one attaches to the conduct of the municipality. Ultimately, the inescapable conclusion is that the municipality acted deliberately and dishonestly and did so with the clear intent of ensuring that Esorfranki is denied the right to participate in a fair tender process as it was guaranteed in terms of Section 217 of the Constitution. Then lastly, what is it with respect that our learned friend contends for when he submits that entertaining and acknowledging a claim in these circumstances will open up a can of worms? What our learned friend really contends for is that a municipality or another administrator is entitled to absolute immunity. And that, with respect, is precisely what all of the authorities do not say. The judgment in Steenkamp, the judgment in Ulinsky, and the judgment in Gore, to name but three, acknowledge the fact that the community does not consider it appropriate for a municipality to be held accountable by way of delict in circumstances where the municipality or an organ of state similar to the municipality acts honestly, makes a bona fide mistake. And with that, we take no issue. But those three authorities also tell a different story. The convictions of the community does not allow for a blanket immunity to be afforded to a municipality, even in circumstances where there is clear evidence, undisputed evidence of deliberate dishonesty, that even in those circumstances, the municipality cannot be held accountable. Because that would simply mean that what a learned friend in fact contends for becomes the law. And that is that organs of state enjoy absolute immunity. That, with respect, we submit is not what the convictions of the community demand. The convictions of the community demand accountability, of course, within limits, and those limits have been spelled out in the three authorities that we have mentioned, which clearly do not find application in these on these facts and do not save the municipality from accountability. Thank you, Justice Madlanga and members of the court. Those are our submissions in reply.
Thank you, Mr. Luderitz, and thank you to both counsel. Judgment is reserved.
Thank you, Justices.
Today's proceedings have concluded. The host will now terminate the meeting.